was subsequently required to submit a report, which I have done, and the ministers have asked me to reopen the hearing session with regard to some additional policy documents that have come forward. Before I can proceed any further, it would be useful perhaps just that we confirm who all the participants are today, and if they are going to be speaking as we go through our discussions. So we'll maybe start with the applicant.
Thank you, ma'am. Marcus Trinnick, a solicitor at King's Counsel, instructed by Peter Nesbitt, a partner in Evershed Sutherland LLP, who is in the room with me. Also in the room with me, Alison Sidgwick, who will be dealing with planning matters today. And from Vattenfall, we have Alison Doherty, Catherine Carr, and Nicola McLennan. That is our team today. Thank you.
And for the councillors?
Good morning, my name is James Finlay, King's Counsel at the Scottish and English and Welsh bars. I have on screen, you can see 4 people today, starting on my left, Martin Ingram, who's instructing me, James Hewitt on my immediate left, who's going to be giving the evidence, myself, and then Elizabeth Tully on my right, who's simply observing today.
Just to say, I can't see Elizabeth Tully. I don't know if other people can see Elizabeth Tully.
She appears on the box on our screen, which is what you can see, but as she's only observing that, there's no advantage for you to see her.
Okay, that's fine, thank you. And for Wildcat Haven?
You're on mute, cool. Shall I go first? Shall I go first?
Dr. Donahue put his microphone on.
Okay. Dominic Woodfield, Managing Director of Bioscan UK Limited, Ecological Consultants, appearing on behalf of Wildcat Haven.
And Dr.
Apologies, ma'am. Yeah, apologies, ma'am. Yeah, Dr. Paul O'Donoghue, Wildcat Haven.
Fine. And we have others appearing on the screen today. We have, I don't see their video, there's Mr. Hammett, Professor Newman, Lynn Rutter, and Ewan Brown. And I was just wondering, perhaps we could get them to turn all their videos on. We'll just check what their role is today. Perhaps with Lynn Rutter, you're visible just now.
Yeah, my video works. So I'm Lynn Rutter, and I'm representing a community group called Friends of the Clash. I'm not proposing to speak, so I think I have nothing to add to this particular conversation, but I am here to report back to the community group.
That's fine, thank you. Mr. Hammock, are you there?
I'm here, but invisible, which my wife might think is a good thing. I will not be speaking. I've made all the points I want to make in my written submission. Thank you.
Professor Newman? You're muted just now. You're still muted. No, you're still muted, Mr. Newman. You need to find that button somewhere on your screen. It was working earlier. Is there something?
It's probably a bar at the bottom of your screen, Julian.
Lost him completely now. He's still there. Yes, rejoins. That's your microphone now, Mr. Newman.
Trying to unmute myself. It caused me to be thrown right up. Okay, can you hear me now?
Yes, we can.
That's good, thank you. I'll only speak very briefly.
That's fine, thank you. Now I see there was Ewan Brown.
Yeah, ma'am, I can deal with that. Ewan Brown, I think, is, as you may recall, was acting as my junior. I hadn't realised he was joining separately as well as on the screen, but so he's acting as my, I'm appearing with him today as well. But he's not in the same room as us.
That's fine. I think, have I caught everybody there? I think so. That's fine. So, as I said earlier, just briefly, the purpose of this hearing is to consider some specific changes in government and local policy that have taken place since the original hearing was convened. The agenda that I've circulated indicates what I expect to cover today, drawing on the areas where I think I need a bit more information rather than looking at the entire case in full. And just to remind participants and for those following online that a hearing takes the form of a structured discussion, which I will lead, inviting the parties to answer my questions and allowing others to respond to the matters raised. I'm happy for parties to raise points and questions that they might have, but they must do so through me, and it doesn't become a cross-examination of each other without my involvement. When I feel I have enough information on a topic, I'll move on. We've got a few bits of housekeeping for today. I expect that we'll need to take our discussions into the afternoon, so we'll stop for lunch somewhere around 12:30, 1 o'clock. And I will also take a short break midway through the morning, but we'll work that in around the agenda items as best fits. It's important with an online event that you always remain courteous and patient with the other participants, bearing in mind that often additional time is required just to respond to questions when they're put through the online platform. And one of the things that's important today, and we've seen it already, is about making sure your microphone is switched off when you're not participating, so that your contribution or the noise in your office doesn't disturb the other people that are presenting information. And of course, we are all going to forget to mute or unmute our microphones at some point today. So please just be patient and let people sort that problem out. The hearing is being broadcast live, and you've all seen Ewan Murray. He will stay in the background, keeping an eye on us and deal with any technical problems that crop up. The event is also recorded for saving as part of the inquiry record and will be made available publicly on our website in the coming days. By participating in today's meeting, you are agreeing to being recorded and for that recording to be retained in our computer system. Now, before I go on to the agenda, are there any procedural matters that any party wishes to raise at this stage? Now, obviously, we'll be to do so. If you need to raise anything, you can raise your hand, and I'll try and keep an eye on the video. But also, there's a hand raising tool you can use in the online meeting platform. You can also use that if you need to, but you need to remember and turn it off if you're no longer wish to participate. So, any procedural matters at this stage? Mr. Finlay.
Yes, we applied to put in a document which is Brady's blog, which just gave some information about how long decisions can take, depending on whether they go to appeal and otherwise, and timeframes. And I understand, I think that Mr. Trinick doesn't object to it, but wishes, no doubt, wish to put something in response.
I hadn't dealt with it by email. Obviously, it came through just a day or so before the getting a bit of feedback there. Sorry, a day or so before the meeting. I'm inclined to accept it, but obviously, I'm interested if any of the parties have an issue with that piece of information coming forward. Mr. Trinick.
No issue, ma'am. Perfectly happy, provided we have a chance to respond. I would suggest a written exchange on that by the end of this week to close that particular process.
Yeah, possible. We'll come to additional submissions in due course. Obviously, wasn't looking at engaging any further written submissions, but happy to see if we can fit something in within reasonable time scales following the closure of the meeting.
Well, that's fine, ma'am. But my acceptance of that Brody's blog is dependent on us having an opportunity to respond to it.
Okay. Well, at the end of the meeting, we'll look at some timescales around that or any other matters that come up through the course of the meeting. Okay, that's fine. Thank you. Now, just to say, anybody that's not participating now, I think most of that's happened, is if they're not actively participating, they can turn off their videos and microphones so that I'm concentrating on the people that might want to contribute to the discussions. That's fine. Thank you very much. I have a few points of clarification. I was going to bring up the Brodie's blog documents. That's fine. We've covered that through Mr. Finley's question. It was a matter relating to the core documents list. It was just to say that we obviously got the 2023 dated version of the LDP, the Local Development Plan, in the last few days. It was a very large document, and the case officer has managed to get the introduction and the policies added to our online site and given the appropriate core document number. The appendices are still to follow. I'm not aware that access to the appendices is going to be crucial for today's meeting, but if it is, we can make arrangements using the link that Mr. Ingram gave in a previous email. I think you've all got access to the whole document. It's just our online site couldn't, or case officer didn't have enough time to reformat the rather heavy appendices. They take a lot of memory in terms of document management. The other thing I just wanted to check from Wildcat Haven's representatives, the hearing statement that you submitted is not attributed to either of you personally, and I just wanted to confirm who the author of the document was, or if it was a joint authorship.
It was primarily me and Mr. Whitfield for Wildcat Haven, ma'am. It was primarily me with input from Dr. O'Donoghue.
And that takes me to another. There's a couple of points of clarification about content of documents, but the first one is about the email I sent a couple of days ago to the applicant concerning the role of the strategic development plan after NPF4 is adopted. For those of you who've been following, obviously we expect the NPF4 to complete its legal processes on the 13th of February, and when that happens, it's my understanding that the strategic development plans across Scotland would be superseded. Ms. Sidgwick's evidence seemed to indicate that she thought there might still be relevance in these documents. And I just wanted to know if there was any update on that particular point before we proceed into the discussions proper.
Yes, ma'am, there is. You are correct in what you said in your email about the effect of the commencement number 11 regulations 23. There's a slight puzzle. I don't think it matters so much, but I note it in that the paragraph 4 of schedule 2 to the 2019 Act, which has been brought into effect by the 2023, will be brought into effect by the 23 regulations on a date, uses the term publication of NPF4 and refers to a section of the 1997 Act, which appears to have been repealed. So I'm not quite sure what's happened there, but I don't think it matters because at the latest, publication means adoption. And if the plan is going to be, NPF4 is going to be adopted on the 13th of February, that'll do. And you are correct on that basis. Mr. Finley may know the answer to my little puzzle if it matters.
Mr. Finley, did you want to add anything on that legal point?
No, we think you're correct. And I'm afraid I can't help Mr. Trinick at the moment, but I'll do my best.
So that's fine. It is rather a tortuous route through the various layers of legislation, and I can understand because it took me a couple of times, and I'm not a lawyer, but it did take me a couple of times to work out how these various documents interact. So I'm quite happy that I've sorted that out because I think it's something that's just a factual piece of information for my report to ministers. It's not got a huge bearing. The second clarification I wanted to make, and it's to do with Mr. Hewitt's statement, and apologies, he did not get any forewarning of this, but I don't think it's a huge issue. If I could take you to page 8 of Mr. Hewitt's hearing statement, paragraph 233, fourth line from the bottom. And it's to do with the council's objection. He states that the unacceptable effects relate to landscape impact. There's no reference there to visual impacts. Now, I'm assuming the council is not changing its overall case here, and that is just an oversight because the direction to the committee reports and Mr. Seale's evidence and the reference to visual effects there are still in place. Is that the right interpretation of that paragraph, that it is just an oversight?
Yes, you're correct, Mum.
Right. Okay. So that takes us now into item 2 of the agenda, and we're going to concentrate for the next wee while on the 4th National Planning Framework, NPF4. It's core document 00325. I'm sure you've all got these documents in front of you that we're obviously going to be having quite a narrow discussion over 2 or 3 key documents today. Obviously, I've got your submissions on it. NPF4 deals with quite a lot of information, so we're not looking at NPF4 in the round. This is not an opportunity to tell me what you think the policy should say or what you would have done if you'd been drafting it. It is about what it tells us now about the effects on proposals like this one for renewable energy or for onshore wind in particular. And although you have made very good submissions on the issue of the spatial strategy and the spatial principles of the plan, I thought it might be a good place to start is just to get each party's impression of the document and how it might affect the renewable energy proposals and onshore proposals that specifically scale of the proposal we have before us today. I might start with the applicant first, again, just look at the headline points.
Good morning, Ma'am. Yes, very sort of briefly to sort of go through the key matters that I would like to highlight. The key issue is the twin crises of nature and climate. And for developments such as this one, we believe that we're addressing both through the generation of renewable energy and the approach to biodiversity. The National Spatial Strategy is important, and it's set out on page 7. And in particular, I draw your attention to the 3rd paragraph and the 1st sentence of that refers to every decision on our future development must contribute to making Scotland a more sustainable place. National developments are not entirely new in NPF4. We did see them in NPF3, but the inclusion of generation of electricity as a national development is a change from NPF3. And there is a difference there. And we've moved from NPF3 having high voltage energy transmission work to NPF4, page 7, referring to strategic renewable electricity generation and transmission infrastructure. And I believe that's a key change. We have regional spatial priorities coming in, and the subject site is located in the northeast. And on page 28 of NPF4, in the 2nd sentence of paragraph 1, we can read that the area will evolve through just transition to move industry and business away from the oil and gas sector towards a cleaner, greener future. And then moving on to Annex C, which talks about the spatial planning priorities for the northeast in particular, on page 128. In the 2nd paragraph after the priority box, there's a box that says priorities box. It talks about greener energy choices, including onshore wind, amongst others, having a natural home here being the northeast, and it talks about them being at the heart of the area's future wellbeing economy. And the only other thing...
Just for a minute, Ms. Sidgwick, I just want to check I've got the reference right. I was trying to find the page. Can you just confirm where that reference is on the page?
It's page 128. Yeah. And there's a box that says priorities in it, and it's the 2nd paragraph after that.
Right, so it's the paragraph in the box. That's where that's fine. Sorry, I've disturbed your train of thought.
No, don't apologise at all. The only other thing I'd just like to add is that the spatial framework that existed in SPP has largely sort of slipped away, although there is a very clear direction that there is to be no wind energy in national parks or national scenic areas, but other areas have support in principle for renewable energy development and wind farms. I think that's all I'd like to say on that one. Thank you.
That probably takes me to the council. If you have anything to highlight that's different or take us in another direction.
Yeah, Mr. Hewitt will come in first, and then I may add something.
Thank you, ma'am. Yes, I think first and foremost, there's quite a lot that we would agree with in terms of what Ms. Sidgwick has already said in terms of the focus on climate change and the nature crisis. Whenever we look at the spatial strategy, the additional points that I suppose we would seek to highlight would be around the just transition and phraseology around that. If we look within part one of the spatial strategy and back at the outset of it, discusses the UN Sustainable Development Goals, there is terminology around the just transition there, and it talks about the empowerment of people to shape their places and ensure the transition to net zero is fair and inclusive. And now I raise that because obviously whenever we look at NPF4, we can see that net zero climate change is matter. The fundamentals of the planning system aren't being shaken up here, in that there's still a role for communities to play and for local people to shape decisions, and there's still a balancing act to be carried out, whether this is weighing up the nature crisis, whether it's in weighing up the impact on the landscape, whether it's considering the contribution towards net zero. This balancing exercise has been carried out in many different decisions, recent decisions. So I suppose our view is that NPF4 and the National Spatial Strategy is formalising and consolidating that approach to a large extent. And just to pick up on the points in terms of the regional spatial strategy and the commentary around the Northeast being a natural home for onshore wind, I believe that section does also talk about other forms of energy and renewable energy in the Northeast. Not to suggest that there are alternative developments to this. That's not what I'm trying to do here, but it does make a point that, for example, solar has a home in the Northeast, offshore has a role to play. So the transition is wider than just looking at onshore wind alone. And in terms of the wider challenges for the Northeast, when we were looking at the shift away from oil and gas, a lot of the commentary around that is also directed to the wider economy and a shift from, I suppose, employment substantially based on oil and gas to employment around renewables, which we would need to consider what kind of contribution renewables are making in terms of realising that ambition. But yes, I suppose to sum up, the key point is NPF4 is really a consolidation of approaches that we have been utilising. And on the point of these now being national developments, in practical terms for us as a council, we've dealt with many national developments for the past number of years, although primarily for transmission infrastructure. Our approach with national developments is to put in a broad high level of support from the outset, so we don't question the principle of development as such. But that doesn't then replace the need to carry out a detailed assessment. So whether or not we were to call this application a national development, be unlikely to meaningfully impact our assessment of the application. Thank you, Mark.
Perhaps I can just add 2 points to that. One, just picking up on what Mr. Hewitt has said, the significance of something being a national development is set out on page 97 of the NPF4, and it goes to the importance and need, or the principle of development and the need for it. And as Mr. Hewitt said, Aberdeenshire Council has never questioned the importance of the development or the need for it. So it's in that context that Aberdeenshire Council's position wouldn't have changed. But once you've accepted the importance and need which designation as national development emphasises, you then go on to you still need to carry out your detailed assessment of it. And that's made clear on page 97. I don't think there's any difference between us. The only other matter on that in terms of spatial framework, again, Ms. Sidgwick is obviously correct, spatial frameworks have gone, but my understanding is that in this case, it was tantamount to being, if not in group 3, old group 3, or still current group 3, but soon to be old group 3, where there was it was considered to be acceptable in principle, and that will be the case under the NPF4. So again, whilst there has been a significant change in the spatial framework, the importance in this case is perhaps more limited than it might be in other cases.
Right, I'd maybe introduce the other parties if they wanted to make any comments on that, the issue of the spatial strategy. Probably Wildcat Haven first, if there was anything you wanted to add.
Yes, please, ma'am. Yes, I think we would draw your attention particularly to the fact that the NPF4 effectively slightly changes the emphasis in terms of the equivalence of the nature crisis to the climate and energy crisis. It does not suggest that one is subordinate to the other, and it's peppered with references to addressing the nature crisis being at the core of decision making, just as much as addressing the energy and climate crisis. One is not at the exception of the other. It also emphasizes, for example, on page 3, we need to make the right choices about where development should be located. And again, that goes to the heart of all of the issues that were explored in last year's inquiry about whether this is the right place. And in that context, the reference to the new concept of the national developments, we would probably make the point that the Clashindarroch scheme, I mean, the NPF4 is quite clear in terms of saying that the national developments include networks of several smaller scale proposals that are collectively nationally significant. It's not saying that each one of those individually is nationally significant. It's saying that they are collectively nationally significant. Now, obviously, there is a threshold level that's set in terms of projects greater than 50 megawatts, and this project certainly qualifies under that criterion, but it is one of approaching 100 such projects in Scotland, and is very much at the lower end of the scale of energy generation in terms of megawatts. So I think it needs to be seen, whereas it comes under that category of national developments as part of that infrastructure network, it needs to be seen in the context that it's quite a small cog in that machine rather than a nationally significant development in its own right, equivalent to the other national developments that are defined in the NP4. I would also perhaps just say that the NPF4 also reiterates the importance of the mitigation hierarchy in terms of underlining and emphasizing the need to conserve and protect in advance of looking for mitigation and compensation and enhancement measures. It's absolutely recognised, including by Wildcat Haven, that development in the right places can deliver biodiversity benefits, but development in the wrong places will generate significant biodiversity harm, which isn't then addressed by suggesting that enhancements and compensation measures outweigh that harm. So in that context, I don't think it represents a step change in planning policy quite so much as a consolidation of principles that have been in the ascendancy for some time and are now fully front and centre in response to the nature crisis. Thank you, Mark.
Do any of the other parties wish to come in on that? Not seeing anybody raising their hands. Does the applicant wish to respond to any of those points, please?
Thank you, ma'am. Just on one point, and that's one of the points made by Mr. Woodfield. Otherwise, all the points made are very fair, and we probably not that far apart. But on this one we are, which is a question of national development, that NPF4 makes it very clear on page 103 that Clashindarroch 2, as an onshore generation facility exceeding 50 megawatts in capacity, is individually a national development. That's what it says. And I wasn't aware there's any dispute about that. On page 97, it said that in the left column, these are significant developments of national importance. That includes Clashindarroch 2. Each one, not collectively, not a small cog. Each one is a national development of a significant development of national importance. That's on the face of NPF4. Thank you, ma'am.
I had some other questions around national developments, which I was going to come to next. Might just slightly out of a slightly different order, but it was a question, quite a detailed question perhaps. Is it, if a project is a national development and on the whole there was agreement, obviously the Mr. Woodfield's taking us a different spot. Oh, Mr. Woodfield, you want to come back on that?
Sorry, Ma'am, I just wanted to just point you towards a reference which doesn't entirely sit with Mr. Trinick's point there. A reference within NPF4 at page 4 and around about halfway down the page on the right-hand column. There's a reference that says 18 national developments support this strategy, including single large-scale projects and networks of several smaller scale proposals that are collectively nationally significant. Now, I'm not going to go behind that and suggest that there's an internal conflict within NPF4 there, but certainly that doesn't necessarily sit. I mean, it makes logical sense to me in that the national development of a Scotland-wide energy infrastructure project is the sum of its parts. It is not a single entity, single development entity. And I think if it's being suggested that it should be confounded with a single nationally significant project, I think that's shown to be slightly misconceived on the basis of this reference, which very clearly points to collective national significance.
Mr. Trinick?
We're clearly in disagreement. Obviously, I respect Mr. Woodfield's view, but if you look at the other types of national development, for example, energy innovation on the islands, which is, I'm looking at sustainable places only, not at livable places, but the sustainable development places, that's page 100 for that one, or page 105, urban sustainable blue and green surface water management solutions, or number 5, Central Scotland Green Network. I can see there that there is a collective approach and that a number of projects may come forward of that type, which collectively are of national importance. However, looking back at page 4 of the NPF4, I am in no doubt at all that the reference to single large-scale projects includes reference to single large-scale over 50 megawatt wind energy schemes. We'll have to agree to disagree. That's my view.
No, that's fine. I get the point. That's quite well made. Thank you. Right. So I had a sort of further question on national developments, which kind of leads on for this. We've looked at the effect of them in terms of the statement of need. Well, that was implied in your hearing statements, but I'm wondering whether you saw anything in NPF4 that changed the way that other policies that we're going to come on and look at in detail. So we're not really looking at the policy, but whether anything in NPF in the national development status changes the way the other policies should be applied in terms of making those detailed assessments. Just go to the applicant first.
Thank you, ma'am. I'll take that one briefly. Yes, I think it does, and I'll be specific. If we look at policy, I'm not sure it's engaged here, in fact, policy 4D2 because it deals with SLAs. But in 4D2, there is a balancing exercise to counter significant effects on the integrity of SLAs, for example, or local nature conservation sites. And I think in that balance, that a national development would clearly be of national importance. I think also in policy 11 that is relevant to our discussions today, that when the decision maker comes to look at what the applicant has done under 11E to present information on various impacts, and the decision maker has to give significant weight to the contribution of the proposal to renewable energy generation. And there again, I think that the fact of a development being a national development comes into play there. Those are two examples I'll give you.
That's fine. Does the council have a position on that question?
Yes, I agree with 50% of what Mr. Trinick said. His example in policy 4D2 is entirely opposite. It's not exact. That's the wording there talks of local importance, but we're told that this development is of national importance, so it's clearly more than just local importance. So it would answer that question. There would be a further question if SLAs were involved about whether something clearly outweighs something, but that is not a matter for you in this case. In terms of policy 11, I'm not sure I do agree with Mr. Trinick. What policy 11 tells you at the end is that significant weight will be placed on the contribution of proposals to renewable energy generation targets. What national development, and I come back to page 97, which is the reference I made earlier, it doesn't give you guidance as to weight. Policy 11 tells you, which I think Mr. Hewitt's made clear was the confirming the pre-existing situation, that significant weight will be given to that. And once you have significant weight, you have significant weight. You can't have, there's no gradation between the word in terms of significance. So I'm not sure it does help in the sense that Mr. Trinick suggested in policy 11. That may be just a difference between us. But where any policy or the application of any policy refers to need or the principle of development, it will be relevant. In the application of that policy. And policy 4D2 is a very good example of that.
Thank you. Mr. Wood, if you want to come in on that, I think I saw your hand up.
Yes, thank you, Mum. Yes, I'd say there's another example of how NPF4 actually strengthens the biodiversity provisions, which is evident on page 9. Cross-cutting outcome and policy links, subcategory improving biodiversity. In the 4th paragraph in that grey box there, it says, most significantly, policy 3 plays a critical role in ensuring development will secure positive effects for biodiversity. And this is the crucial word. It says it rebalances the planning system in favour of conserving, and that word comes first, conserving, restoring and enhancing biodiversity, and promotes investment in nature-based solutions, etc. It's that word rebalances. That is clearly signalling a change from previous frameworks, and it supports that position that the emphasis on biodiversity conservation has been elevated within the new framework as compared with its predecessors.
Mr. Trinick, you wanted to come back on that?
Just very briefly, with apologies to Mr. Woodfield, we're probably going to disagree once or twice today, so there we are. I think I disagree with what he says there. I think rebalancing is a different point. Well, the point Mr. Finlay makes, I'll say it again today, we're dealing with a new document and we're exploring it together and its meaning. So he may be right, he may be wrong. I stick to what I said, but there is room for doubt. I understand that.
That's fine. Yeah. I was just really exploring, as you see, we're all learning how to find the nuances in this document and how they might lead us down a certain path. And it takes me back to a question, and it was just something that cropped up in Mr. Hewitt's submission about just transition. Obviously, there's a just transition plan, which is one of our documents. I don't mind if you want to stray into that in this question. Just transition is one of the principles. Right. Page number. Yes, it's the document page 4, and it's obviously the first of the spatial principles. But I'm interested, obviously, Mr. Hewitt raised the issue of shaping places. And I just wonder to what extent the just transition concept, as you can see it from NPF4, or possibly in other documents as well, how much of that is actually about things like land use and environmental impacts, the things that the kind of development consent processes are perhaps more focused on, and how where you think the just transition concept sits in as a land use planning decision where there are environmental effects. So perhaps start with Mr. Hewitt this time and just see if he could expand a little bit more on this idea of the shaping places part of it, whether or not that's evident in the concept of just transition elsewhere.
Thank you, ma'am. Yes, I mean the just transition. I've brought that up because it's quite a thread that runs through the document. It is very evident from reading it that it is a bit of a priority, and I think that reflects the fact that when we look at NPF4 and we look at the wider move towards net zero, that there are quite significant implications for the country. There's quite significant implications for certain portions of the country, and that is pulled through in the regional spatial strategy, where it says, for example, that the Northeast is a natural home for certain kinds of developments, and so those points already been made. And I think that when we're talking about significant changes occurring, and we're talking about wind energy, we're all very well versed, and the arguments have been well rehearsed that there are quite often landscape and visual impacts associated with them, with visual impacts being really the crux of our objection to the matter. But in terms of the just transition, I suppose the reason I brought it up in the context of planning is that planning really does fulfill this very strange niche, as we all know, where it is quite technical. It pulls in expertise from a lot of different places, but it is fundamentally quite a democratic process where we allow communities to be involved. We allow individuals to comment. In the case of how we've come to a conclusion on this, we've taken it through 2 of our area committees and to our infrastructure services committee in order to get the members onto it. And it's really about ensuring that, notwithstanding the technical nature of this, that people have an impact, buy-in to development that is being done to the areas that they live in. It's development that's being done for communities and not to communities, I suppose. I don't really have a completely clear answer on how we can address the just transition. Because it is a very complex matter, but in tying into the energy strategy and just transition strategy, my views on that, it's primarily an energy policy. It's very economically driven and really seems to almost sidestep the issue of place and placemaking, sense of place, which are obviously very important to a lot of communities, a lot of individuals who live in these areas. So I think it's in planning balance. When we look at the just transition, it's very, very important that we address the issue head on and address those concerns head on. And we're very clear that if we're saying that the benefits of the scheme outweigh the harm to the community, what are the benefits to the community? And that's very clearly articulated and carried through. And we understand whether these are short-term benefits in terms of into the construction phase, or whether these are longer term ones beyond the operational lifespan. I can expand on that if you wish, but I think I've said quite a lot there. So I'll end there.
Could I just add to that very briefly, just to point out the reference to just transition on page 7 of the NPF4 talks about must involve and be fair to everyone. That's the 4th paragraph down on the left-hand column. And to answer your question directly, how that might affect it might affect the weight that you give to the local consideration and local objection. It could affect the weight. How it will affect the weight, how it might affect the weight, obviously a matter for you. But it's clearly saying that that's an issue, and I think that if tying it into the process that you're engaged in and reporting to ministers, that's how one aspect of how that might tie in.
That's helpful, thank you. Mr. Trinick, do you want to come back through Ms. Bridgwick?
Yes, thank you, ma'am. I think a very brief response on this is that just transition is going to become a clearer concept once the draft energy strategy and just transition plan are finalised. I think the feeling I have at the moment is that this is more macro than can be accommodated in individual project decision making. And indeed, at page 27 of the draft energy strategy, it talks about preparing Scotland for a just energy transition. And it does so in extremely, and I'm not criticising, it's very high level terms. There was a box there saying by 2030 Scotland will, etc. You can read it, you want to read it out. But I think that the point is it's quite high level. I have difficulty in seeing at the moment how you apply a just transition concept at a project level. It's simply not well defined enough to do that. Therefore, I'm not sure it's a matter to which you can give real weight at the moment in the absence of understanding exactly what it means. We'll know more later.
Does anybody else want to come in on this idea of just transition? No, it's fine. Now that takes me to the next subheading, which is policy 1. We've touched on it already. Oh no, sorry, I've missed a bit out. Sorry, there was something here. Taking things out of order. Sorry, Ms. Sidgwick, you've confirmed that the applicant's argument doesn't really rely on the Scottish planning policy presumption in favour of sustainable development. Now, obviously, with Scottish planning policy being superseded imminently, the council maintains that another concept from Scottish planning policy, the right development, the right place, remains evident in the new policy documents. I think Mr. Woodfield referred to it as well there in his introductory remarks. So I'd really like to just look for to highlight the elements of NPF4 that are confirming the concept of the right development, the right place is still, or is being reiterated or re-established by the publication of NPF4. Maybe start with the council first, because obviously it's their main argument.
If you go to page 7, left in the column, 2nd paragraph.
Yes, got that.
And there are a host of other areas within the document where emphasis is given on protecting the environment, and we'll come to policy 4 and 4A in due course. But just to see if I can find you another where the where that right development in the right place is identified. That also figures in the onshore wind policy statement, just to pick up a cross-reference, paragraph 3.6.1. And the, it's very clearly stated at the outset of the document, and that idea runs through it. And if you go to policy 4A, for instance, which talks about unacceptable development, it's really the development proposals which, by virtue of their type, locational, scale, of unacceptable impact, will not be supported. That's putting into policy form the right development in the right place, and that's absolutely consistent with previous decision makers' approach on the issue. So there's clearly no change to the right development in the right place, which is a phrase that was used before, is used in quite a number of Scottish ministers' decisions. And the reuse of it in NPF4 must have been purposeful and does not denote a change of approach.
If it helps, Ma'am, I think the reference Mr. Finlay was looking for is on page 7 in the first column. The National Spatial Strategy. I mean, this means, yeah.
Got that. That's fine. Thank you. Mr. Trinick or Ms. Sidgwick, do you want to come back on that issue?
Yes, I do, ma'am. If I'm doing some of the talking, it's between Mr. Finlay and I, we've now done 5 of these sessions. So,
Of course.
on UE, I disagree quite fundamentally with what's been said. That the phrase "right development in the right place," Mr. Finlay knows my feelings about that phrase. That it is no more than a statement that there is a planning balance, as opposed to having the wrong development in the right place or the right development in the wrong place, or other permutations. The right development in the right place is no more than a statement that there is a planning balance to be applied. And in policy 4A, the word "unacceptable" is no more than a statement that there is a planning balance to be applied. It tells you absolutely nothing about how to apply the balance. Now, we got used to SDP and NPF3 and ways in which the balance might be applied. And if only in the interests of consistency of decision making, we got a large number of Section 36 or Planning Act decisions on wind farms, which reflected a sort of medium average position. There was a general consistency. The difficulties emerged as we entered the climate emergency, and we got the legally binding emissions reduction targets, and the system struggled to catch up with what was happening in advance of NPF4 because planning policy was still SPP. And we could see the struggles that went on in decision makers' minds in trying to come to terms with what was happening. But we now have NPF4 and have the ministerial statement, which is outlined, but it's been quoted, his closing remarks to Parliament on the 11th of January, paragraph 7 of Alison Sidgwick's hearing statement. NPF4 is the biggest change to our approach to planning in Scotland in 75 years. It's a turning point. It's not a general policy update. It's about change in planning with courage and determination to make difficult decisions. And I would acknowledge that's also about the nature crisis, not just about climate change. It is a big change. And the way that I view this is that if you have a line, one end of which is yes and the other end is no, and the tilt point along that line has changed as a result of NPF4, we would say, others would say different, that more is now required to justify a refusal of a clean energy project, provided that that project also delivers on the nature crisis. I agree that you can't have one without the other, and that Mr. Woodfield and I are probably together on that, although we disagree on the evidence. But that's the way I view it. I don't think the right development of the right place is a meaningful phrase by itself.
Thank you. That's fine. Mr. Woodfield, did you have anything on that particular issue?
Nothing to add particularly, ma'am. I'm just thankful to see the equivalence of the nature crisis being acknowledged by all parties.
It's fine, thank you.
And could I just get briefly on that? Just to, in a specific point and a general point, to respond to Mr. Trinick. The specific point is if you go to page 7 and look in the paragraph above the reference to right development in the right place, the concluding words talk about protecting, recovering and restoring our environment. And so the additional part of this point is that Mr. Trinick may have his own views of the importance of or sense of the phrase right development happens in the right place, but it's clearly not shared by Scottish ministers because they've reflected it as that headline in their policy, in effect. The second point is about the biggest change since 1947. I just wish to make the point that there's no dispute between the parties that NPF4 does herald the biggest change since 1947. I mean, one can just look at the fact that it's now part of the development plan, and national policy is now part of the development plan, with all that entails. There are other significant changes within NPF4, but not everything has changed. And our stance on behalf of the council is that you have to look at the individual application of policies to see what has changed and what hasn't changed. And to fall back on headline pronouncements is arguably going to mislead you. Not everything is the biggest change since 1947, and not everything is the biggest change to how decisions were being made beforehand. And just as an example, the elevation of the nature crisis to equivalence with a climate crisis is a big change. But the importance of the climate crisis has been acknowledged consistently in renewable energy developments for some time.
Whitfield?
I would just add to that, Man, that the mitigation hierarchy is something that carries through from the previous planning framework to this one. There is no suggestion of a step change in the preeminence of that as a decision-making tool. And going back to Mr. Finley took you to the first paragraph on page 7, the order protect first, recover and restore, definitely secondary, is still front and center.
Thank you. Mr. Trinick?
We agree with Mr. Whitfield. We just disagree on the evidence.
Okay, thank you. Right. Okay, so the next topic was policy 1 itself, and we've kind of strayed into it already, and it's the dual nature of the climate and nature crisis and how policy 1 is affected. It's on page 37 of the document. It's good. So the policy advises that significant weight should be given to the dual crisis in plans and decisions. We've touched on already, and it's about the key implications of the approach, bearing in mind what we've just talked about, the right development, the right place. So I don't know that we need to go into it in much more detail, but it was something I wanted to just highlight. If you think we've covered it sufficiently about the difference between the significant weight given both crises and the right development, right place. Is there anything else you wish to add on that? Maybe start with the applicant. Is there anything you want to?
Thank you. I think it's very important to acknowledge that this is a document of national policy, and for the first time it's part of the development plan. And of course, in cases such as this, section 36, the development plan doesn't have primacy, but it's a very new document. It's about to be adopted in less than a week's time, and it's applicable to the proposed development, and I think it should be given substantial weight as part of the decision-making process. with all the policies which are contained in Part 2 of NPF4, it's important to read the policy intent and the outcomes, and it's also important to read them in the context of the document as a whole. And until the 13th of February of this year, there's been no clear policy statement, as far as I'm aware, on the weight to be attached to the global climate and nature crises. And I think this is an important step, and one that is very clear that the decision maker needs to take into consideration, and it's very clear that they should take significant weight into consideration. Up until now, it may have been the case that it was taken into consideration, but that was the choice or at the discretion of the decision maker. This is new territory in terms of the decision making balance, and it reflects back to what Mr. Trinnock was saying a short while ago.
I'll come back to you, Mr. Newman. I'll just let the council come back on that point first, then I'll pick up your contribution. Does the council wish to come back on that issue?
Yeah, thank you, I think that the key point we would raise is, yes, acknowledging that this is being posted into the development plan. The thing to consider is, would it have made a meaningful difference to how this has been assessed up until this point? If we look at how we have assessed it as council, our energy policy is broadly supportive. There's high level support in principle for wind energy developments, for example, which then is carried through with a detailed assessment and a balancing exercise being undertaken. So that kind of ties back to the point made earlier that really NPF4 in this regard is a more consolidation of approach. The energy climate crisis has already been well addressed within planning, and whilst the policy does say that significant weight will be given to the climate and nature crises, it doesn't say that this is at the exclusion of any other consideration. It doesn't say that this policy outweighs every other consideration within the plan, so the document still needs to be read as a whole. Thank you.
Mr. Newman, I think you wanted to come in on this point.
Just a question, if I might ask you, Madam. We seem to have moved from talking about the NPF4 to the Aberdeenshire Local Development Plan, but I assumed that we were discussing Local Development Plan as a separate document later on. Am I correct in that?
I think you might have picked up just a reference. We're dealing with policy 1 of NPF4. So it's the wording of policy 1 of NPF4. If I or someone else used local development plan wording by accident and nobody noticed, then apologies if I've misled you. But we were certainly going on to the next item in terms of the topics in the agenda, which was the implications of policy 1. So we haven't strayed into the Aberdeenshire local plan, although it is possible throughout this that people will be cross-referring from other documents, and I'm not going to stop them and say, no, you can't make that point just now, because cross-referring between these documents is actually quite helpful as we learn how the interplay between the policy documents might work. But apologies if we misled you. We're definitely still in NPF4 territory.
Thank you.
Yeah.
Thank you.
Mr. Woodfield?
Thank you, ma'am. Yes. On policy 1, I think to me it may be just a question of nuance. To me, it represents a slight change in how, to take Mr. Hewitt's point, in how you would approach the assessment and the decision-making process for a scheme such as this. Previously, there was a general presumption in favour of permitting renewable schemes, quite rightly so. And then you looked at the biodiversity considerations to see if there was anything there that was sufficient to justify stopping that or refusing that. Now I think those two things are required to be considered right at the outset, rather than starting from the premise that the presumption in favour of a scheme simply because it's a renewable scheme. There now needs to be equivalent presumption that if a scheme does not further progress towards tackling the nature crisis, then it starts from a position not of presumption. It may simply be nuance, madam, but that's I detect a slight change of nuance there.
Fine. Does the applicant want to come back on any of these points before we move on to my next question? So
I don't think there's a great deal between us on this. The document's not old enough for me to take nuances at this stage. I'm just looking at the words and I just see what the words say. So I don't think there's anything to come back on.
Mr. Finlay, you raised your hand there.
Yeah, just to reinforce the point, Mr. Hewitt's point, the council has made it clear in a number of places that it agrees that great weight should be given to the contribution that this proposal might make to climate change goals. That position hasn't changed.
My next question, I think, was straying into the point that Mr. Woodfield was making, and that's really whether or not, by identifying the nature crisis as being given significant weight, whether that means the other policies of the document, which govern matters such as biodiversity, policy 3, I think it is, whether or not the relationship between that policy and policy 1 is dictated by the equal billing of the nature crisis. And so it's really just about again, it's a question, it's quite, I suppose, maybe more kind of me thinking out loud as much as anything, how the crisis in policy 1 might interplay with potential successful compliance with policy 3 on the biodiversity matters. We're going to come to biodiversity in more detail before, but it's just whether or not the balance policy assessment changes. Does anybody have a view on that point?
With hesitation, yes, it does. But it does so really by virtue, policy 3 tells us how. And I think we'll come on to policy 3 later, so perhaps save my comments and Alison's comments for that. There will be developments where actually those words of policy 1 cannot be implemented because for certain types of development, there's no relationship to the nature crisis. There are certain types of development which have no relationship to climate emergency. In the case of onshore wind, however, both are relevant. We acknowledge that. And policy 3 is relevant. So everything comes into play.
Does anybody have anything to add on that? It's a minor point really at this stage. I'm not seeing anybody desperate to contribute on that. So that takes me into probably the meat of our discussions on NPF4 now is the policy 11 itself on energy. I've mostly going to look at landscape and visual matters. It's page 53. I'll just get place of NPF4 and have a few questions on it. But I really want to start kind of quite an open-ended question, and that is how best to interpret section part 11, sorry, policy 11E, subsection 2, and the reference to significant landscape and visual impacts. And just to invite people to give me their interpretation of how that policy might be applied, or that element of policy should be applied. I'll probably start with the applicant.
I seem to have been deputed to progress this particular paragraph. I think you have to start at the beginning of E. In addition, project design and mitigation will demonstrate. So that's a duty on the developer to demonstrate. how the following impacts are addressed. And I think the words "are addressed" need to be approached properly. I certainly don't think it means satisfactorily addressed. I don't think it means resolved. But I do think it means there is a duty on the developer to show, whether through the EIAR or otherwise, that it has given proper attention, due attention to the factors listed in terms of potential adverse impacts. It's certainly doesn't mean eliminate significant impacts. There are going to be significant impacts as recognised in E2. So I think that's the first point, how to address that phrase. And then coming on to E2, we can see what it says, so we don't need to have an interpretative exercise here. It's an either or, that developments can be, if the impacts are localized, they will generally be considered to be acceptable. Not always, generally. That's a planning judgment for you. Or if impacts are not localized, nevertheless, E2 is satisfied if the developer can show appropriate design mitigation has been applied. That too is a planning judgment. I think also to recognize that design mitigation, it isn't just about landscape and visual effects, of course. You cannot design a site so as to solely reflect the landscape or the visual amenity of the area. The numerous other influences which I needn't categorize on design, and that must be recognized in approaching E2. Then there is a question of what localized means, and I note what Alison Sidgwick says in her hearing statement 228 about that. I think I take the approach which I think she takes, that since there's no metric involved in the word localized, you can't apply some quantitative metric. It's a qualitative exercise. And I would say it's based on the scale of development and expectations of what a certain scale of development may do, the spatial extent of the significant landscape and visual effects. And I suppose if I was in the happy position of being a decision maker, I might ask myself if the spatial extent of the significant landscape and visual effects of the project I was looking at were what I would expect for a development of this size, or whether they were in some way different. And there are schemes I've looked at, other people have looked at, where you see effects you perhaps didn't expect. They go wider than you expect, or they're more intense than you expect. You know our evidence in this case, and I won't go into it, but I think that's a fair approach to the issue. Let me just refer briefly to, let's get the right paragraph out. Forgive me. I don't need to go there. That's fine. The other point to make is it isn't and or. The other point to make about E2 is it must be read with the penultimate paragraph of policy 11, requiring significant weight to be given to the contribution, etc. But we've already been there. Just going for a minute to the Aberdeenshire Council hearing statement, where it deals with policy 11. I don't know if the start of 228 means that Aberdeenshire Council takes the view that it's not an and or, but it's an and. But certainly, I think that's covered adequately in policy 11E2 itself. In terms of localized impacts, I would be surprised if any planning was made that a landscape impact of 4.8 kilometres was not localized in terms of the expectations for a scale of the scale of wind farm we're considering here. That sounds very localized to me indeed. So this is just two comments on the Aberdeenshire Council statement in the context of what we're talking about. Thank you, ma'am.
Councillor, I think would you like to come back on how best to interpret, or how you would interpret RE2?
Yes, ma'am. We'll do it in two parts. I'll go first, and Mr. Hewitt will then sweep up my mistakes. We agree with much of what Mr. Trinick has had to say. If you look at E as a whole, and particularly the introductory comments, it doesn't import a development test, which could be another way of putting what he said. In a way, it's equivalent to the Electricity Act. It's a requirement that certain things are taken into account, and if they are taken into account, it doesn't mean that the application is successful, and if they aren't taken into account, it doesn't mean they're going to fail. But it's a requirement to take certain things into account. That said, the word acceptable at the end of E2 does purport some form of test, but I think that's better seen in the context of policy 4A. That's really a reference back to policy 4A about what's acceptable or unacceptable. It's not of itself importing a test. The criteria in E as a whole are similar to, not identical to, those criteria that appear in 169 of SPP. And they perform the same function. They are factors to take into consideration and are now factors that have to have been addressed. And so in overall approach to interpretation, although I put it in a slightly different way to Mr. Trinick, I don't believe there is any real difference between us. I'll just say, as Mr. Trinick's heard me say before, that and/or is a dodgy legal expression. You probably get away with it in a policy document, but it doesn't help with precision. But what that does lead on, and the area where I do disagree with Mr. Trinick as a matter of principle, this is looking at not whether you would expect something different from or different extent of impacts from a wind farm. It doesn't say that. It's looking at the particular impacts of a particular wind farm sited in a particular location. And so that significant impacts on Tapa North at 4.8 kilometres might well be considered to be more than localised, depending upon the particular location, scale, design of both the wind farm and the extent of impacts on the landscape feature which are identified. I think Mr. Trinick goes too far to that end. And I agree it has to be seen in context of the concluding paragraph or paragraph 11. It also has to be seen in context, as I think Ms. Sidrich made the point, of policy intent, policy outcome, and the local development plans. And just to note under local development plans, that the idea that full potential should be identified is in fact just a read through of para 155 of current SPP, which similarly requires full potential to be identified. That's a good example where there hasn't been significant change in an aspect of NPF4, notwithstanding that, as I said earlier, the overall NPF4 has changed matters from a broad sense significantly. But in terms of general approach to E, those are our submissions. I'll hand over to Mr. Hewitt now to deal with localise and whether that's a changing concept or whether that's a concept that's new. So, Mr. Hewitt.
Thank you. I'll keep it brief. I don't have an awful lot to add there, but in terms of localized impact, it's an approach that we've seen before in previous decisions. For example, Federesso wind farm is one case where localized impacts were according to the decision that was arrived at. So really, this isn't the point. There is that this isn't a fundamental change of approach, and that there is recognition that these developments can and often do have localized impact. But again, that is counterbalanced by the application of other policies within the document, and perhaps most importantly, as Mr. Finlay said, policy 4A, that's perhaps jumping ahead slightly.
Just before I finish, I know Mr. Hewitt's made reference to FETR SA just as a matter of context. That, I think, came out after our hearing. It's not a core document. I'm not applying for it to be made a core document, but if you wish to have it as a core document, I'm no doubt both sides would be happy for that to come before you. But it's just an example, so I don't need to burden you with another decision unless you really want to.
No, that's fine. Mr. Trinick, do you have a view? I'm happy to accept that it's a reference to a decision that's happened.
I don't think we need to see the document. I accept fully what is said about FETR SA decision, but I do disagree with Mr. Hewitt that we have a continuation of the same approach here, because of the words will generally be considered to be acceptable. There have been cases, I can start referring to past decisions as well, where effects that subjectively at least might have been considered to be localized have nevertheless been rejected. The advice has changed, and those words will generally be considered to be acceptable are a step change.
Is anybody else minded to come back on that point over the interpretation of E2? See anybody else? I think we've covered that. That was very helpful. Thank you. I appreciate you probably have discussed that on a number of occasions so far, and will do again, I think, in the coming days. So, but it needs to be submitted into evidence for my case, unfortunately.
Ma'am, could I ask you to have a comfort break very soon?
Oh yes, yeah, sorry, well remembered. I think this is probably not a bad time to come. I wonder if we could just, before we stop, if we could just look at policy 4, because it obviously has been referenced by the council. It's on natural places and its relevance to landscape impacts. Ms. Sidgwick's statement recognises that Part A is a relevant matter for landscape, but actually Mr. Hewitt doesn't rely on policy 4 Part A, or at least I couldn't see it in his statement, with regard to an assessment of unacceptable landscape or visual effects. So it really, hopefully quite briefly, and then we'll take a break, is whether or not the natural environment that's referred to and quoted in policy 4 Part A is actually landscape, as opposed to other natural environment matters such as designated nature sites and things that are more prevalent in the rest of that policy. So perhaps maybe start with the applicant. See if you agree that natural environment embraces landscape.
Yes.
Yes, good. Does the council want to come back on that issue of policy 4 in case I've missed something in the statement?
No, well, yes, we do want to come back, but we agree that with Mr. Trinick. Yes, I think the statement isn't, I would accept, as clearly drafted as it might be, but in 2.2.6, Mr. Hewitt did refer to policy 4, and he, when doing that, had in mind 4A. I agree he hasn't stated that expressly, and when later on he comes in 2.2.11 to the planning balance, that is also written with regard to policy 4A. Now, I will accept, and as no doubt Mr. Hewitt would, that that could have been better expressed, but the intent was clearly to refer to policy 4A and consider it to be relevant. So I would hope you're not misled by that, and I'm grateful for the opportunity to raise it and Mr. Trinick's clear acceptance that it's relevant.
Yeah, that's fine. Then I think what we'll do is we'll take a break here, because I've got another question about policy 11, but it takes us into a different topic part of it. And we'll come back. Let me see, that's 11:25. Is 10 minutes sufficient, for everybody, or 15? 10 minutes fine. So we'll restart again at 11:35. Thank you.
Yeah, okay, I got that.
I mean, the trouble is with all of these things, it's the policy basically said
Right, that's 11:35 on my computer. Right, that seems to have everybody back. Alison Sidgwick's video is not on, but I'm assuming she's with you. Oh, that's fine. Yeah, that's everybody there. Thank you. Right, so I'm still in policy 11, but I'm going to look at part C, and that's about maximising net economic impact. And I know I had indicated I was going to focus on the landscape parts, but it's just something that it came out through my additional reading before today's meeting. Now, the Council doesn't really identify any concerns regarding the extent that the development maximises net economic impact, which is the quote from Part C. And the applicant, through Ms Sidgwick's statement at paragraph 46, it summarises the key elements of socio-economic benefits as evidence of policy compliance in this regard. But I just wanted to see if Ms Sidgwick could give me a bit of a guide as to how I establish that that is evidence of maximisation, as opposed to just evidence that there would be socio-economic benefits. And obviously that would be start with Ms Sidgwick or Mr Trinick.
Thank you. I think it's a challenging wording there, because it's what we're being asked to do is maximise net economic impact, including local and community socioeconomic benefits, including employment and businesses and supply chain and things. And I think this is this sort of requirement to demonstrate the maximisation of net economic benefit is something that is new. It's not something that when the application was prepared, that was a sort of test that we were being asked to met or a challenge we were being asked to rise to. But I think what I can say is that the evidence or the written statement from Graham Blackett of Bigger Economics sets out a lot of the opportunities associated with this, as does the relevant chapter in the EIA and the report that is appended to the rear of the planning statement that was submitted with the application. And the planning statement reference, just for your information, is CD 1.8. And to the rear of that, there is a report that covers off a lot of socioeconomic information. I wouldn't propose to run through that here and now, but in terms of demonstrating what the applicant has done to show that, insofar as possible, socioeconomic benefits will be part of the proposed development, those are the places you could go to look. Mr. Blackett's document, just for your reference, is, let's check for you. CD 515.2, and then he refers to a number of documents in there which are also 16, 15.21 and 22. Yeah.
Sorry, just add to that, ma'am. I think we have to read this for the onshore wind policy statement, which has a section 5.2 starting on internal page 29, which is addressing the supply chain. And it's worth looking at that, I think, because what we must recognise is that this is a transitional scheme. In other words, it was thought of, planned, and the EIR was done before this policy advice, and we couldn't possibly react to it, therefore. And paragraph 524 of the OWPS notes that Renewable UK are currently working to fully understand supply chain opportunities. We expect the report shortly, and we'll use it to inform our approach to maximising supply chain benefits. So we are in a transitional phase. This is a transitional project, and supply chain is in a transitional phase itself, as recognised in the OWPS. So I hope that we wouldn't be held too strictly to account on the word maximise, given those two factors. I think there's a long way to go before we understand the metrics around that.
Does the council want to come back in on that point? I know it's not something you've relied on in any detail.
Thank you, ma'am. I think first and foremost, a lot of what has been said, we would be in agreement with, in recognising that this is something that is newer within the document in terms of the maximisation aspect of it. I think that from our point of view, it isn't necessarily clear that the benefits have been maximised, but that would be tempered with the fact that we would be awaiting guidance on how that is to be demonstrated, how that is to be taken forward as part of the application. So it isn't something that, you know, in the worst case scenario, it's not something we would be suggesting as any grounds for objection at this stage, certainly. It's something that is emerging as a strand of these projects.
And is anybody minded to come in on this point, Mr. Woodfield, or no? Right. Well, thank you. I just obviously it isn't the council's part of the council's case or an evolution of their case, but it's obviously need to be part of my report to ministers, and I was trying to establish how best I could represent that point. So that takes me now to the next topic heading, which is policy 3 on biodiversity. Now, I've really got one sort of fairly lengthy question on this, so bear with me on this. It's a bit of context. So policy 3 applies to national developments, specifically in part B, and in terms of subsection 4, that there should be biodiversity enhancements, and these must be in addition to those required for mitigation. So again, Mr. Trinick's alluded to it, there are disagreements about whether or not the mitigation measures are sufficient for certainly around wildcat. And I'm not really wanting to open up a debate about whether or not they are sufficient, but I really want to explore whether the policy provides any direction on what might be additional to the mitigation measures. Ms. Sidgwick, you've obviously in your hearing statement, you've given quite a lot of references to the mitigation measures in the EIA. And you're indicating that you feel the mitigation goes beyond what is required, which at that point was to render potentially significant effects to an acceptable level. You've also, in response to the Onshore Wind Policy Statement, referred me to Mr. Bradshaw's recognition 3.4.5, that's CD 11.9. But I'm really looking for a bit more substance to your position that the mitigation measures exceed what is required to address EIA requirements, and where I might find those references, what you've drawn on. And again, we're not in a position to share a technical debate about mitigation and the design of it, but I'm really looking to see how you've reached that decision.
I think it's in some ways it's not dissimilar from the discussion we had a moment ago, in that this is sort of into this transitional phase and things, and this demonstration is not something that was required or was set out in policy previously and things. So I think that is part of it. But I also think that it's important to look at the wording of condition number 22, which covers the need for a habitat management plan and a species protection plan. That's obviously a document that, should consent be granted, would be signed, well, the documents would be reviewed and signed off by Nature Scott and also Aberdeenshire Council as the local authority. And the wording in there includes reference to enhancement. So it includes mitigation in terms of that, but under the second paragraph, Part 4, Roman 4, says measures to restore and enhance woodland and peatland habitats, and to improve habitat connection for wildcat between Clashindarroch Forest and the large woodland blocks within the Strathbogie WPA. And I think that is the mechanism for Aberdeenshire and Nature Scott to ensure that as far that the enhancement is carried out to their satisfaction. And I think if you're looking to see examples of enhancing the natural environment and things, there is the Annex 1 of OWPS, which doesn't refer to a species, but it does talk about habitat management and peatland restoration and provides an example of some work that has been done by Scottish and Southern Energy.
So just in the terms of policy, you're not seeing anything in the policy that gives us, I think Mr. Trinick used the phrase metric. There is no way of measuring additionality in the terms of the policy at the moment. That's my interpretation of it. Additional is fairly open-ended in terms of quantity or scale.
That's correct. I know that Nature Scott are working on a Scottish biodiversity metric so as not to have to rely on the UK metric. And that the results of that, and Dr. Woodfield may know more. I don't know. They're not out yet. That's all I know. We also know that the draft Scottish biodiversity strategy is going to be finalised later this year. So there's a lot we still don't know. And I think the important point, which Alison Sidgwick has mentioned about the condition, is the inherent flexibility within it. That any condition, any scheme submitted under the condition must be required to respond to circumstances at the time. In other words, to the metric at the time and to the biodiversity strategy when finalised. You will wish to look at the condition to make sure that it's appropriately phrased. I'll just also refer to the OWPS again at 3.5 that addresses biodiversity, and that again acknowledges the transitional phase we're in by reference to the biodiversity strategy and the emerging position. 3.5.6 is particularly important, and it's important to recognise that this is where the climate change and nature crises come together, that schemes such as this are expected to not only deliver climate benefits, but also nature conservation benefits, and we fully recognise that. That's what it says.
Colleague, come back to Mr. Finlay first, perhaps.
Yeah, it's just to alert you to a new document that's come out this morning called Transitional Arrangements for NPF4. It's a letter from the Chief Planner dated today. I've forwarded a copy to Mr. Trinick. It doesn't really, it confirms one of your initial queries about the approach to strategic development plans. On a quick view, it really doesn't impact much from what we're talking about. But there is a paragraph on biodiversity, and it does reinforce Mr. Trinick's point that Nature Scott are producing a final version, that the final version of their guidance will be available shortly. So it's just to note that that does exist, and that to draw everyone's attention to the transitional letter that has come out this morning, but that certainly on, and I've just had a quick look at it whilst others were making their submissions on biodiversity. There's nothing in it that I would suggest is going to cause anyone any issues, but it may be something Mr. Trinick and I and others may want to make brief submissions in writing, and it may only be a paragraph, a sentence or two, judging by my understanding of it. It's got much more to say about quality homes and wind farm. It's just to draw that to your attention at this stage. It seems an appropriate moment to do so.
Well, I'm wondering, is that something that we do need to add in? It could be that other colleagues of mine will have the benefit of that if they come to carry out their additional hearings in another few days' time. I'm wondering if it's worthwhile adding it to the evidence and allowing some submission on any relevant parts of it, just in writing.
It definitely should be added as a core document, because it's definitely something that ministers will expect you to have taken account of when issuing your report as I say, I don't think it's going to, judging it as neutrally as I can, make any substantive difference to the submissions you've heard already. There's some specific advice on policy 1, but it really doesn't take matters any further. Policy 3 says what it says and what I said it said, and the rest of it is just about the formalities of transition. There may be further guidance, that's why I suggest that a short sentence or two should probably suffice, and it should definitely be for other colleagues of yours that are having hearings tomorrow and in the future may well want to have regard to it as well. And we will, I'll just notify Mr. Trinick and his agents that we will send that off to the programme officer for tomorrow's hearing, so that the reporter has that in advance.
Just to add, ma'am, that I'm happy to send that to your case officer and copy in the other parties for this hearing as well. So I'll just do that.
Okay, thank you. Mr. Trinick, does that sound like a reasonable approach to this document? You may not have had a chance to read it.
I have just read it. I don't think we need actually to make further representations on it. I have to say it's pretty clear on its terms. It does have something to say about policy 1, which I'll leave you to read. We've been through policy 1. On policy 3, yes, it tells us about research on the metric, and it does say there will be some proposals that will not give rise to opportunities to contribute. It will be for the decision maker. I don't vary that in aid of our policy. I think we do need to contribute to the enhancement of biodiversity. I'm not sure there's a lot in this document to make representations on, but if you wanted a sentence or two, I'm happy to do that.
I'm neutral either way at the moment. I'm just going to take Paul O'Donoghue's raising his hand there. Do you have a view on this transitional document?
Ma'am, it was in reference to your question to Alison before about the enhancement. You asked for. Could we stay on the topic of just the document at the moment, and I'll come back to you. So okay, we're just trying to resolve how to handle this document. I'll come back to you in a moment. Mr. Woodfield, did you have a comment on the relevance of the document?
Just very briefly, ma'am, just to point out that to the extent that Scotland is in the process of devising a metric for assessing net enhancements, net gain, how to assess net loss, that will be habitat based. So if it is anything like the system that applies in England. So on that basis, it will be of limited use in terms of the wildcat issue specifically.
Okay, so I think, are we in agreement that we accept the core document in and I take account of it? I'm not worried if I don't get comments from it. If you're happy that I'll get sufficient from reading it and understanding how it relates to the primary legislation and guidance. I think so, that's fine. So we'll accept the core document, right? That's fine. So we'll come back, because we were coming back round, and I think so the question really was about the additionality of the biodiversity improvements in relation to the agreed mitigation measures, or not agreed mitigation measure, whichever side of the argument you're sitting on. So I see Dominic and Paul both have their hands up to speak. Who wants to go first then? Is that happy?
Dominic, go first. Dominic, go first.
Okay, well, I'll try not to trespass on anything you're wanting to say, Paul, but I'll pass over to you after. Your question, ma'am, seemed to relate specifically to point 4 under B of policy 3. I would just remark that we're another year on from the inquiry, and I guess it's a question through you potentially to the applicant. Policy B4 says that any kind of enhancements, and we know that we disagree on what's compensation and what's enhancement in relation to the evidence here, but let's go with the applicant's inference that there's net enhancement from this project rather than de minimis mitigation and compensation. On that basis, this clause in the policy says that it should be secured within a reasonable timescale and with reasonable certainty. And it suggests that management arrangements for long-term retention and monitoring should be included wherever appropriate. Now, what we're hearing from the applicant is the same as we heard last year, which is that this all can be dealt with later by way of condition. And one of the matters that came up was the lack of progress from the applicant on, because this would require control over third-party land. It would require agreements with third-party landowners, and the applicant showed that it had singularly made very little or no progress on those matters. So I guess the open question, and it's anchored in relation to policy 3, is do we have any better certainty on any of these matters? Because we certainly didn't have that last year. And if we do have additional certainty, or we're going to be given the suggestion that there is additional certainty, where's the evidence of that?
Maybe take Mr. Donoghue now, in case his point is overlapping the same thing, and then I'll come back to the applicant.
It certainly was overlapping, ma'am. Yes. There's been no detail provided at the Wildcat hearing, and there's been no detail provided when you asked a very simple question. We suspect that's because there's been no progress on that matter. And just on the mitigation, just to make the point that the mitigation put forward was wholly incompetent in terms of current mitigation for the disturbance that will happen to the wildcat. We'll hear, and I'm sure we'll hear again in a minute, about planting schemes. They'll take 10, 20 years to occur, to mature. We just heard about connectivity between habitat, but again, no details. You'll see connectivity of habitat is embedded in policy 3, and enhancing habitat is embedded in policy 3. So yeah, while we hear the right words, there's no substance to them, and the mitigation, the timescale of mitigation is utterly in contravention of this policy, and utterly it's just not relevant. Wildcats cannot be expected to wait 20 years for trees to grow. So I just want to make that point very clearly. That, you know, unjustified and kind of hollow claims about habitat connectivity and enhancement, fine, but there is no detail provided to that. And even if there was, and this is the really important point to make, even if there was detailed information about that, it certainly does not compensate for the habitat loss that will take place and the immediate and very real threat to the lives of those wildcats in the Clashindarroch forest. And I think that's
okay. We've taken. So I think the issues there are obviously we don't want to debate because it's a matter for the separate inquiry session that we had is about the scope of mitigation. But I do take your point about timing and the reference to that in policy. I think that's quite important, and the certainty over the works. And it might be that I take that. But I saw Mr. Newman, you raised your hand there where you wanted to come in before I go back to the applicant. No, okay. So I really just want to come back to the applicant on these matters then, obviously, around the timing and certainty that's embedded into part 4 of policy 3.
I've really got no more to say, ma'am. You've had my closing submissions. You've got the evidence support, quite sure. I'm not going to go back into the evidence. You had the discussion on conditions. You have condition 22. We say that satisfies 3B policy 3B4 at Wildcat Haven. I respect their view. Says it doesn't, and that's all I want to say.
So that's no progress then.
And I stress that we're not here to talk about the evidence today.
Ma'am, so that's no progress, no update, no additional certainty. That's relevant to policy 3.
Yeah. Okay.
Sorry, ma'am, that's not what I said. I said you have the submissions, you have our clear position, you have the discussion on conditions, you have a condition. I'm not going to get into an argument here, but you have a difference of position, and we say that condition 22, as offered, enables policy 3 in NPF4 to be satisfied. I'm not going to say any more.
Mr. Donoghue?
Yes, ma'am. Mr. Trinity's just proved our point perfectly, so thank you.
Okay. No, I accept. I just need to stress to the inquiry, obviously, at no point in the run-up to this have we ever asked the applicant to give us any update or additional evidence on these matters. So read into that it's important that the inquiry hasn't asked for that the process is still in limbo while the Scottish ministers consider the original case. So this inquiry doesn't give an opportunity to open up the debate over the mitigation or scale of mitigation. So I think I was really looking at the terminology of the policy and how that might assist us in applying to this particular scheme at this point in time. Now, I think that was everything I had on policy 3. Yeah. And it takes us into policy 4 and natural places. We've touched on it briefly. Oh, sorry, Mr. Paul O'Donoghue.
Sorry, ma'am. There's a lot more to discuss on policy 3. In my opinion, you raised one subsection of it, but in fact, most of it needs discussion. And I think Dominic's gonna go first on that, and then I will join if required. But there's a number of points, policy 3A, B, and indeed subsections 1 and 3, and point D that all need to be discussed at this hearing, and they're all relevant to this application.
Well, if you remember, the hearing is purposes for me to take forward things that I didn't fully understand or I felt that needed clarification through the hearing. I do have your statement. So remember, I'm not only taking into account what's said out loud today, I'm taking into account what's written down. I'll allow a little bit of discussion, but I was trying not to kind of go into a full policy analysis because obviously the information is there. I didn't think it was quite as uncertain as the issue of additionality, which I was really wanting to pull out today. But Mr. Woodfield, if you do want to kind of fairly as briefly as possible highlight the points that you're worried about in terms of this policy.
I'll be brief, ma'am. You have our hearing submission and it makes most of these points. I would simply just draw out the preeminence of the mitigation hierarchy throughout policy 3 again, the emphasis on protect and conserve as the first port of call. You have our evidence on how this scheme doesn't follow that hierarchy, but attempts to leapfrog to the end of it and default to compensation. What is new in policy 3 is this requirement that the receiving environment for a development proposal is left in a demonstrably better state than without intervention. I think, again, on the basis of the evidence, Mr. Trinick will no doubt disagree, but on the basis of the evidence, there is no question that the receiving environment, in respect of its value to wildcat, critical value to wildcat, as a species on the very brink of extinction, will be left in a worse state than without intervention. And just to open up the floor to a point that I know that Mr. O'Donoghue, Dr. O'Donoghue wants to make, under D, that there is a requirement. We did touch on this in the inquiry. We felt that because the impacts on wildcat resonated at national level, potentially the single most valuable residual population, then the cumulative impacts should have included any other wind farms nationally that engaged with that species. And we returned to the issue of cumulative impacts in that policy. And we have suggested that a new alternative proposal, very close by to Clashindarroch 2, the Infinity proposal, has not been adequately considered as a viable alternative that actually generates more in terms of megawatt input, but with substantially less risk of catastrophic impacts to one of Scotland's most iconic species. Now, you have our hearing statements, but I don't know if Dr. O'Donoghue wants to add anything to that, but that's probably the key point to make out of policy 3.
Okay.
Yeah, of course, yeah. So just the policy intent is to protect biodiversity, reverse biodiversity loss. At the wildcat hearing, the applicant conceded that the Clashindarroch is a national site of importance for the Scottish wildcat. It was conceded that at least 5 wildcat territories will be negatively impacted and represents a significant proportion of the existing population. And I will also make one important point. evidence provided by the applicant themselves. It was the paper, you'll remember it, ma'am, and I can provide the note for it, about the German wind farm situation, where they show that during the construction phase of wind farm development, it leads to the killing of wildcat kittens and displaced wildcat.
Yeah, you know, obviously we are covering evidence that's already been presented, and I did make it clear that we weren't going to open up the matters that were discussed at the previous session on wildcat in the inquiry session. So I'm just trying to keep. I know this is something you're very passionate about, and it's quite hard sometimes to move between policy and evidence and worries. But because we're looking at policy, I'm really looking at the matters that would impact on how the policy is applied. Mr. Woodfield was very kind in actually focusing on that, and I take his points regarding cumulative impact on the difference in the policy intent. So if I could just keep you, in that sphere, because that's the purpose of the policy hearing.
Okay. Policy also mentions part B about the environmental impact assessments, where will only be supported where it can be demonstrated that the proposal will conserve, restore, and enhance biodiversity, including nature networks. Again, this application cannot be deemed to have conserved or restored crucial habitat. It talks about best practice assessment methods, also in part B. Now, again, just a flag, as we discussed, there was serious deficiencies in the assessment methods used to identify the key receptor species, which is the wildcat at this site. That's directly relevant to policy 3 part B. And you'll I'll refer you back to the evidence, ma'am, about the deficiencies in the methodology around camera trapping, for example. So just to jog your memory, where unbaited camera traps were used to try and find wildcats. So you'll remember that. And also placing camera traps near wind farms isn't best practice assessment methods. So that's directly relevant to.
I take your point that you're drawing through your concerns from before into that particular point about methodology and EIA techniques.
Yeah. And part B3, an assessment of potential negative effects, which will be fully mitigated in line with the mitigation hierarchy prior to identifying enhancements. Again, the negative effects have been acknowledged and conceded by the applicant.
I don't think you can say that, because the inquiry outcome was not resolved. There were two different opinions. So please keep on topic with policy and don't read into something that happened at the previous inquiries if that was a conclusion.
Well, it was just the fact that the applicant conceded that there was negative impacts on wildcat territories. It's not my conclusion. It's just what they said.
Yep. Okay.
And again, just to reiterate and reinforce what Dominic said, there is an Infinity proposal which at the time of the wildcat hearing was not well advanced, but at this point it is considerably more advanced, and you'll note that Wildcat Haven contacted the inquiry to ask that a further discussion was held on the proposal, because we think now it's directly relevant to policy 3D, and that proposal poses a much lesser risk to wildcat habitat than the Vattenfall application.
Yep, your point was made, and obviously that wasn't the. I made a decision not to open up the inquiry to consider the other proposal, because that was a decision I made. I'm not going to go into it again today. Is that your points then on the policy matters before I ask the applicant if they want to come respond to that?
Yes, ma'am.
Yeah, thank you. Mr. Trinick, do you need to come back or want to come back on any of those points just now?
No, ma'am, because we're going back into the evidence. I've nothing more to say. This session is about understanding policy, not applying it. The only point to make is that although I note what the policy intent of policy 3 is, looking at policy 1, it doesn't say that greater weight should be given to biodiversity. It says that significant weight should be given to both the climate and nature crises. There's no weighting given within policy 1. Thank you.
Mr. Wood, feel like to come back again on that point?
Sorry, we just need to get some simple matters settled here. The suggestion that we are trying to elevate unnecessarily the weight to be attributed to biodiversity conservation above that of the energy crisis is rejected. But in this situation, where you're dealing with potential impacts and risks, high degrees of risk, as acknowledged by the applicant, to a species that's on the very brink of extinction, then it's very difficult to conceive of a situation where the impetus to handle the nature crisis and towards biodiversity conservation can carry any greater weight. Well, that's really the point.
I'm not going to say any more. Anything I do will just prompt more evidence. Thank you.
Okay, that's fine. No, thank you. I hope that's okay. I did want to raise the implications of policy 3, but I was trying to focus on the bits that I felt I could benefit from discussion, because your statement was quite clear on how these matters were tying back to your original evidence to the inquiry. Dr. Donoghue, I'll take one last point on this, but I really don't want any more evidence on the actual inquiry matters.
No, it's just absolutely fine. So I just want to make a point, and this actually runs across the whole document really, and it's the interplay between the nature and climate crisis. And one point that hasn't been made today, and that should be made, is that actually functioning healthy ecosystems are one of the best ways to mitigate the climate crisis. In fact, without them, no matter how many renewable energy schemes are in place, I won't tackle the climate crisis. And that point hasn't been made. Healthy functioning ecosystems are the best tool to combat the climate crisis, and significant predators such as the wildcat play a crucial role in those natural functioning ecosystems, which are essential to resolving the climate crisis. The Amazon rainforest is more important than any number of wind farms. And so habitat and functioning ecosystems, that interplay is not done, and that's not been made. That point's not been made. We've been discussing them separately, but what NPF4 does is draw them together, and actually it's the ecosystems, the functioning ecosystems, that support our efforts to tackle the climate crisis.
Yeah, okay. I think I get that point, actually. I think that's well made. Thank you. So I've covered what I wanted to do in policy 3. I was about to go on to policy 4. And that was taking us, policy 4 is natural places. I asked a question earlier on regarding the connection with policy 11 and landscape matters. So we've dealt with some of that already. But I want to ask a question really of the way the policy should be interpreted, and to check that it hasn't changed. My understanding at part F of policy 4, policy 4 deals specifically with protected species, which is an issue for us in this case. My understanding is when we look at the words adverse effect on a species, that in general, the policy would take forward what we consider to be the residual effect after mitigation, rather than the initial effect, which is identified in this case. So we know from our inquiry session and the evidence on wildcat that effects are accepted, but they are mitigated, and that it's the residual effects are not significantly adverse. Now, there's a difference of opinion on that, but in terms of applying the policy, my understanding is that you would work from the residual effect assuming that there was agreement on the effectiveness of mitigation. I'll probably ask the applicant that and see if they have a view in terms of how they would interpret terms of policy 4F, really the first section.
We agree with your approach.
Mr. Woodfield?
Thank you, ma'am. Yeah, I think there's probably nothing between us on this particular point. The key issue, obviously, is whether the mitigation will actually be effective, and whether it will result in a residual impact that is agreed and has a sensible measure of certainty around it, which does not apply in this case in our submission.
I think that was all I was going to raise on.
Ma'am,
sorry, yes.
Can I just go back one point to E? I think it's probably just worth flagging that the precautionary principle, which there has been question marks over, given the withdrawal of EU law that's happening. It's good to see the precautionary principle carried through into national policy, even if Scotland reluctantly is being forced to leave the EU. And in that context, I think that goes back to the evidence that you heard last year in relation to the absence of the precautionary principle being applied by the applicant in this case, and its continuing relevance to decision making.
Mr. Trinnet, do you want to come back on any of those points?
No, we note policy 4E. If I say any more, I get into the evidence.
Dr. Donoghue, you're raising your hand again, is there? Get microphone, please.
Yeah, it's just on point F as well. If there is reasonable evidence to suggest that protected species is present on a site or may be affected by proposed development, steps must be taken to establish its presence. And I think, there needs to be an understanding of what steps have been taken to establish its presence by the applicants on this site, and as we've heard in evidence, they are deficient in our opinion. But I just want to understand from the policy, maybe you have an interpretation of this, of what steps must be taken to establish its presence, because we heard that most of the evidence about wildcats was collated by a third party and not the applicant itself. So I just want your view on the steps taken to establish the presence of a protected species.
Yeah, it's not quite how the hearing session works. I don't give evidence on these matters. I try and tease it out of others. I take your point that the whole of policy 4F might have a bearing on the case you made to the inquiry session on mitigation and methodologies. And I think that's what I would take from it. It's not for me at this moment to say to you how I'm going to apply policy, because I'm still deliberating that. We're still understanding how these policies should be applied.
Thank you, Mark.
Now, okay, I'm really coming to the end of my questions about NPF4, and I have raised the issue of other NPF4 policies. So the applicant has highlighted compliance with policies 5, 6 and 7. The council, however, identifies 10 relevant policies from NPF4 in Mr. Hewitt's statement. Could you turn your microphone off? But not policy 7. So I'm really wondering if the council and the applicant could just have a look at their relevant list of policies. These are policies that are relevant, but perhaps not determinate on the matters in dispute. But just to agree what they consider to be the list of relevant policies from NPF4. I'll give you a few minutes just to have a look at them. Mr. Hewitt, I don't know if you've had a look at it. I'm probably interested in policy 7, which I think is the one relating to historic assets and things. I think that is a matter for the inquiry in its broadest sense, to do with scheduled monuments and other cultural heritage matters. Could I ask that question maybe in specific, as whether or not you're content that policy 7 does have some relevance to the broader issues that apply here?
Yeah, I would agree that it probably should be on our list.
I don't know if Ms. Sidgwick have had a chance to look at the council's list and whether or not there's anything that's giving you concern.
I think what I would say is that 1, 3, 4, 5, 7 and 11 are the key policies. I think some of the other policies that are mentioned in 2.2.2 of the council's hearing statement are policies that could be applied to a number of different types of developments and things, and insofar as they're relevant to wind farm developments such as the one we're discussing, they're addressed really in policy 11, which I would consider to be the key policy or the principal policy against which the development falls to be assessed, and then also looking at other policies as they are relevant.
Yeah, and does council have a view on that?
In general, we completely agree with that approach, and 2.2.2 wasn't intended for any other purpose. I think we just add that whilst policy 11 is clearly the most important policy dealing with energy policy, policy 4 is also quite significant. It's 3 policies taken together that are the most important policies. But apart from that, I agree with absolutely Ms. Sidgwick's comment on the relevance of the other policies.
Thank you. I don't know if Mr. Woodfield, if you had a view on any of the policy matters across the rest of NPF4.
Not really, although I kind of raised a quizzical eyebrow at any suggestion that policy 11 is in some way more important than the application of earlier policies, 1, 2 and 3 in particular. I'm sure that's not the intent, but I'm sure everybody would agree that the NPF4 needs to be read in the round. But there is a particular reason why the overarching policies 1, 2 and 3 and 4 are placed higher up in the hierarchy, I'm sure.
Ms. Sidgwick, do you want to come back on that, or Mr. Trinick?
No, I don't think so. I'm not sure that policy 2 is relevant, I have to say, but otherwise nothing to say. I think policy 2 is not about, if I can dig it up, it's about buildings. It's not about the sort of development we're talking about here.
That's fine. So just, and then sort of catch-all questions, or any other policies in NPF4 that you want to draw attention to today that you feel should have been discussed in more detail? We've covered the key ones that came through from hearing statements.
No, thank you.
No, that's fine. I'm looking at the time now, it's 12:30. I'm about to start looking at onshore wind policy statement and then the LDP. I'm wondering, do you want to kind of crack on with the onshore wind policy statement until 1 o'clock, see if we can cover most of that, and then we'll reconvene to look at the local development plan and the draft strategy document after lunch? Does that seem like a good use of our time? Yeah. Well, nodding. Okay, so onshore wind policy statement. I'll just get that screen. It's CD3 026. I've got 2 or 3 points to raise. I've got 2 topics here. One is the actual target of additional gigawatt installed capacity, and the other is relating to the issue of balancing environmental and economic effects or benefits. So the first one is just to try and look at whether or not, in the context that onshore wind has always benefited from policy support, and I think everybody's agreed on that, and always benefited in certain recent times on an uncapped policy support. There's never been a maximum figure given for it. What do you think are the implications for the decision-making process, now that a megawatt target has actually been published and is now confirmed as a government policy? That's what difference does having the target mean? And probably start with the applicant.
Thank you. I think having the target is important. I think it's something, the idea of 20 gigawatts by 2030 first came about in the 2020-2021 programme for government, a Green Affairs Scotland, if I've got the title right and things. And then it found its way into various position statements and things. We now have it in a approved government policy document, and I think that puts it fair and square as something that should attract significant weight in the decision-making process. If you look at the box on the bottom of page 6, it's very clear that it is a minimum installed capacity of 20 gigawatts. And to my mind, this isn't that different to that there is not a cap on targets. There is an ambition and a target for a minimum installed capacity. That doesn't say that we should get to 20 gigawatts, for argument's sake, in 2029 and stop. And I think that's all I would say on that in terms of getting the importance of those targets. I'm very happy to cover the challenge associated with reaching those targets if that's something else you would like us to go into.
Well, if you think that's I think it's relevant, the target. I think what I saw just when listening to you here obviously is the issue of where previously we had support for or uncapped support for it. We now have a date, and I wondered if the fact that we now have a date where we need to get to that point places greater focus on the issue of the target, perhaps, and it might be your evidence about challenges might be useful in that respect.
I think it certainly does focus the mind. I think it is a challenging target. I think if you look at the table at the bottom of page 5 under paragraph 1.1.5, it might be easy or relatively easy to be lulled into a false sense of security about how we might get there. But I think if you read the footnote, which is in fact, or I assume it's a footnote, but it's the double stars at the top of the following page, it provides some caution on assumptions to be made about these figures. Now, I've covered that to some extent in my hearing statement for the original inquiry, and I would just refer you back to that, but would like to just sort of flag one or two bits. It's in section 5 of my original hearing statement, just for your reference. But we know that not all applications will gain consent. There are applications, there are always applications that fail. We know that there are some applications that are for repowering and some that are for tip height extensions. So we've got a degree of double counting going on, if you like. We know that there are some applications that have planning permission or deemed planning permission, but they're not really considered viable to build. And that may be to do with matters such as costs associated with aviation mitigation or grid connection and that kind of thing. We're aware that there are a number of consents that are due to expire before too long. And we're aware that some wind farms are starting to reach the end of their operational lifetimes, and that will come before 2030 in certain instances. So they have to be taken out of the equation. There is a negative that has to be applied there to balance it. And I think that's all I'd say on those issues.
Just to add to that, ma'am, we've got the Brody's blog, which you've admitted. And the reason that I do want to make a response is that that response will say that, first of all, the average decision time from application to a decision following a public inquiry for a Section 36 case is roughly 3.5 years. Evidence which we want to bring forward in response to the blog tells us that there is quite a long period. I mustn't give too much evidence yet. Long period between getting a consent and generation. And if you add those two periods together, you come back to approximately 2023. The corollary of that is that if a project may have to go through public inquiry, and an awful lot do at the moment, maybe less in the future, I don't know, we don't know, then if you don't start pretty soon, you're not going to make 2030 generation. And that in turn puts, my own phrase, a premium value on projects which are in the system now to achieve that target by 2030. Timescales are important, and I'm very grateful to the council for producing the Brody's blog, to which we can add with evidence on the time taken between decision and generation. Thank you.
Fine. Mr. Woodfield, you have a question at this point? Your microphone, please.
I do, ma'am. I'm not sure if it's of assistance, but Cedric has taken you to the table at 1.1.5 of the onshore wind policy statement. The figure that's given for in-planning stroke consenting process of 5.53 gigawatts is different from another figure which I've seen coming out of the government, which relates to an environmental information request response, where they produced an Excel table showing 83 schemes, either in scoping or in application, the total, minimum total megawatt output from which was 7,500, so 7.5 gigawatts, of which, incidentally, Clashindarroch scheme represents about 0.75%, so 0.71%. So yes, I'm not sure if that evidence is, which appears to slightly be contradictory to the evidence presented in the onshore wind statement, is relevant. It's from dates from around about a year ago. I can certainly provide a link. It's a government information.
Yeah. Yeah. It's always difficult about producing evidence on the hoof on the day. I think I'm not inclined to kind of open up the inquiry process to take more information after today's hearing. I certainly take your point that that table will reflect a point in time and might not now be a true reflection of where we are in 2023. I accept that, and I think that might be perhaps doesn't necessarily stray too far away from the Sidgwick's point, is that these things are evolving all the time.
That's entirely fair, ma'am. I think the point to take away is that those figures may not necessarily be absolutely correct, and there's clearly a margin of estimation around them.
Yeah. Does the council want to come in on this point regarding the effect of the target date and the timescale?
Yes, can we do it? And I approach it as a matter of principle. I think one has to be very careful about the approach to this, because policy 11 of NPF says that you give significant weight to the contribution to renewable energy generation targets. And it tells you to do that whether they're, even if they're being met. So there's no policy which says you should give more than significant weight. I raise that for this reason. It might be the case in 5 years' time that it looks as though the targets are being met. But an argument that you should then give less weight would be met, and in our view rightly met, with the argument that they're targets, not caps. Now, if you're meeting the targets and you don't give less weight, the corollary of that, at least the logical corollary of that, is that simply because you're concerned you might not reach the target, you give more weight than you're already meant to give. It's not an absolute balance on one side or the other, but that's why I'm saying you have to be careful about giving weight to targets, because there's been a host of decisions saying that, and indeed you reiterated it in your opening comments, that these are targets, not caps, and that's well known. And the weight to be given to renewable energy development would be is set out in policy 11, and it's not dependent upon the extent or otherwise to which you're reaching the target. So that if you were if there was no doubt that the 20 gigawatt target was going to be met, you would still give significant weight to renewable energy development. So by way of overarching point, one has to be very careful about how you factor in where you're reaching the target. And the second point is to reiterate what's said, is that the position in the OWPS is a historical position at a point in time, which is the point you've just made. And I'm then going to pass over to Mr. Hewitt to deal with Aberdeenshire's somewhat limited experience in terms of time taken for developments to come forward and what it is aware of in terms of other authorities.
Thank you. Yes, just picking up on the point of timescales and within Ruby's blog, we can see that timescales have generally been speeding up. In our, as Mr. Finlay has said, our relatively limited experience in Aberdeenshire, we have had 3 wind farms, Federesso, Clashindarroch and Glendy. Federesso has been determined, I referred to that earlier, but in terms of timescales for that, the consultation would have went to, or came to Aberdeenshire Council early in 2019, with our response going to the Energy Consents Unit in 2020, early 2020. There was matters around additional information which stretched that timescale slightly, but it ultimately ended up at PLI as well, which would have been held in November 2021, and the decision was reached in September 2022. So kind of the timescale is perhaps still longer than certain parties may wish, but that does show that are aligned with really what is shown within Ruby's blog. Decisions are generally speeding up. I accept the point that there's other bits in the process beyond consenting in order to deliver the sites, but there is still scope for projects to come forward. We're not solely reliant on what is within the pipeline at this point. Looking at, or turning to other sites, I'm aware that at other inquiries recently, the Highland Council has discussed giving evidence on their potential development pipeline. I believe it's a number around the potential developments that they're aware are close to coming in. We don't have the same potential pipeline within Aberdeenshire, but the point to raise there is that the targets are Scotland-wide. They are not directed to any individual local authority. Yes, it's a collective responsibility within across the country to deliver upon this, but it's not the case that it's saying X amount of development must happen in a particular patch. And fundamentally, the assessment of it does go back to NPF, as Mr. Finlay said, and Policy 11 in terms of the weighting and support given to renewable development is more so pulled through that document than through the targets in the offshore wind policy statement.
Is that you finished, Mr. Hewitt? Right?
Yes.
Okay. So, Trinnick, you want to come back on that?
Yes, there are 4 points quickly. Firstly, we mustn't forget that it's not just a question of these targets. There are legally binding emissions reduction targets as well. And those are highly influential, I think, in a decision that if there is evidence that we are dropping behind meeting legal obligations, that is at least as, if not more important than, a policy target set out in the OWPS. Secondly, I take Mr. Finlay's point about you can't have greater weight than significant weight. That's actually, I think, not really the point. If a project won't be generating by 2030, then it can't benefit from the advice about 20 gigawatts by 2030. Clashindarroch, too, has a grid connection date of 2026. If consented, it will make a contribution by 2030. Thirdly, In terms of the figures in paragraph 115, I don't know whether they're up to date or not, but the fact is that that is the evidence for the inquiry. Those are the figures we have. Unless you want more evidence updating those figures, then those are the figures on which we rely. They're the figures of the Scottish Government. And of course, they change. The final point is I'm rather amused by the council's position. We didn't produce the Brody's blog, they did. And it's the Brody's blog that led me to say it's 3.5 years from an application to a PLI decision. Very helpful information. Thank you. It may be that the council can get it done quicker, but as I say, it's their evidence, not ours. Thank you.
Right. Is anybody want to come back on those points at all? I don't see any hands up. My other question, just around that, and obviously Mr. Hammack indicated at the start of the session that he didn't intend to contribute, but I was just wondering, and I think Mr. Woodfield referred to it as well, about looking at the megawatt contribution from Clashindarroch as a percentage of either the current installed capacity or the future target capacity. And by looking at it as a percentage, it becomes quite a small figure. And Mr. Hammack's position is that means that in a way that it's less valuable, less important. And I know the applicant will disagree. It's not that I'm looking to question it on that point. It's more just whether or not there's anything in the onshore wind policy statement, or indeed NPF4, that tells us we should be judging renewable energy projects and testing them against that sort of calculation. I'm just looking for your thoughts on that. Perhaps the applicant might have a view on that.
As far as I'm aware, there isn't anything that says if you're above or below a certain percentage, you get a sort of higher weighting, if that's what you like. I think it's clear that national developments are not singled out in NPF4, but they are the over 50 megawatts applications that Section 36 is, and for them there is a sort of acceptable in principle, subject to consideration of a wide number of issues and things. So I don't think there is anything that says if you're sort of below 1% of what's needed to get us to 2030, you have any greater or lesser weight than, say, something that says it'll take us 10% of the way there. I think what is clear is that between 1995 and 2002, so when the first project was consented to installation, we've only managed to install 8.7 gigawatts of electricity. We've now got, or 8.7 gigawatts, we've now got less than 8 years to the end of 2030 to get ourselves up to 20. I would suggest that every bit helps and every bit counts.
Does the applicant want to come back on that?
Do you mean the council?
Oh, sorry. Didn't mean the council. Sorry, it's getting your lunch. I apologise. My blood sugars must be getting low.
I think we've made our submissions on the AW Press. It's not part of our case that the percentage it will contribute. It's a national development.
And then I see Mr. Woodfield and Dr. Donoghue want to come in again. So whatever order you want to go in.
I'll just make a very quick point, ma'am, that yes, there's nothing specific says that something that deals with a fraction of a 1% contribution should be given lesser weight if it's over 50 megawatts. But clearly, a scheme that's proposing 100 megawatt delivery is going to make a more important contribution towards meeting renewables targets than a scheme that delivers only just over the 50 megawatts. So I would imagine that in any kind of common sense application of policy, a scheme that delivers a bigger chunk is going to be given greater weight.
Dr. Donahue, did you want to come in on that point? Your microphone, please.
Ma'am, yeah. It comes down to a risk reward. So if you have a very, very small development, which this is, with a very, very large potential risk, then I think that is a material point to make, and that's a theme through various policy documents about the risk reward, about the net benefit. So yeah, I think the size of the developments in relation to the risk that it poses is entirely relevant and should be considered, particularly when there is alternatives such as a larger development with a lower risk. So I think I'd invite the inquiries to look at that and take into account potential benefits of this development in relation to the extraordinary risks that it poses to a critically endangered animal.
Does the applicant want to come back on that point?
No, we're back to it again. No.
Okay, that's fine. Now, and the last point takes me into the issue of balance. That's referred to in Chapter 3 of onshore wind policy, and there's references in the ministerial forward to it as well. The Council highlighted various elements of the document that support their contention that the decision-making process must still balance benefits against adverse effects. That's clear from their statement. Ms. Sidgwick, your statement acknowledges that that process is in place, and we've heard that today in people's evidence. But at paragraph 99, your state of your statement that thresholds have increased. So I'd like to hear more about the issue of changing thresholds, and whether or not we can find where that position is. I think Mr. Trinick mentioned or some of the evidence on a running scale between 0 and 100. You know, where has the threshold moved to? Can we find that point that it's moved to?
No, you can't. There's no metric here. It's a matter of judgment. I do see the forward to the NPF4 what is said about, while it's imperative to meet targets, it's also vital this ambition is delivered in, etc., etc. And Chapter 3 has a number of similar passages in relation to shared land use, in relation to peat and carbon-rich soils, in relation to biodiversity, in relation to the landscape. I'm not going to rehearse them all because that would be very boring. But yes, I mean, I said earlier, I won't repeat it. The balance has changed in the way which I believe it has. And I don't think I need to say any more. You have my evidence on that, so I won't repeat it. But I think that when Mr. Hewitt said earlier that NPF4, and I suppose by extension the OWPS, consolidation of approaches, I fundamentally disagree. That these documents do mark a step change, and I think a different approach to the planning balance is required. So it's not about the wording of policies, and we'll deal with that when we come to the LDP. It's about the way the policies are applied and the balance is struck. Thank you.
Does the applicant want to come back in on that issue of changing or increased thresholds?
The council might come back, ma'am. Sorry.
Oh, sorry if I've done it again. Yeah, I really am needing my lunch. I promise I'll stop as soon as this question's finished.
I mean, Mr. Hewitt said that very clearly in his statement of opposition in that, so it follows we disagree with Mr. Trent. We don't agree with his scale approach. The tests are the same. The balance, there's no suggestion of a change to the balancing exercise or step change. There are changes in the document. Things are made clearer than before, but in terms of the actual application, the balancing exercise, we maintain our position as set out in Mr. Hewitt's statement.
Ma'am, I wonder if just come back on one point there. If you go to CD 729, which is the Rothas inquiry report, and that was issued before NPF4, obviously, And I'll try and find the right paragraph. I think it's 3/181. Whenever I find it. Long report.
You say section 3 or?
Have to bear with me, ma'am. I'm just trying to find it. What that paragraph says, and I will give you the paragraph reference when I find it, if you would allow me to, is and that was reporter Mr. Seaton who made this report, that he acknowledged that with climate emergency, that the way in which you approach the planning balance had changed. That was prior to NPF4, and he drew a distinction between his position in the Rothes case and the prior position he had previously taken on another wind farm. And I think Mr. Seaton had it absolutely right in what he said in that paragraph, which I will find you within the Rothes report. And that was prescient in terms of NPF4. And you can tell him I said so.
Mr. Finlay?
Yeah, Mr. Trinick will no doubt be telling Mr. Seaton that personally on the Kirken wind farm case, but I will be telling Mr. Seaton that unfortunately for him, Scottish ministers were very careful in their acceptance or otherwise of his conclusions. And if one looks at the decision letter on Rothes 3, you'll find that the sentiments to which Mr. Trinick has relied upon do not form part of Scottish ministers' conclusions on the acceptability of the proposed development, which begin at page 23 of that document. And in our submission, the approach that they've taken there bears out the approach Mr. Hewitt has set out in his statement. I noted that Rothes 3 wasn't referred to in the hearing statements of the applicants. I've no concern as to Mr. Trinick referring to them now, but that may be a matter upon which you, if it is to be significant reliance is to be placed on it, that you might need further short submissions on, just so you have the right paragraphs from Mr. Trinick and myself. Mr. Trinick's paragraphs are reasonably well rehearsed in other cases, so they don't come as a surprise to me. And I'm not suggesting what he's saying now has taken me by surprise. And my response won't be taking him by surprise either.
That's paragraph 2.181, which is on internal page 58 and 59 of that CD. I'll leave you to read it now. I know that the ministers did not specifically endorse what reporter Seaton had to say, but nor did they disagree with what he said. I needn't rehearse it, ma'am. It's there. You have it.
I'm happy that I just take this as something I have a look at. I don't know that I need to create new evidence or exchanges on it. I think it's sufficient, especially as it's a decision that is now predating NPF4. And I think therefore it's part of a story along the way towards NPF4, perhaps not a decision made in that context. So I'd take a couple of looked at in that view. So I think having it in the mix is useful, and I'll certainly consider it.
I'm very happy with that approach, but just to note in particular on page 23 that the language that ministers use, because they do reference NPF4 because it was clearly well on the horizon by this stage. They say remain clear from NPF4, as well as the onshore wind policy statement refresh 2021 consultative draft, that this is a matter which should be afforded significant weight in favour of the proposed development. So it's the use of the word remains, and it should is matter that should be accorded significant weight. They're not suggesting there's a change brought about by NPF4 in the draft format that it was then in. So there are other points. Obviously, one needs to read the whole of the decision letter. But I'm grateful for Mr. Trinick about lack of specific endorsement. It's a matter for you how you read that. And Reporter Seaton's comments are, he displays a logical train of thought that is open. One can either accept, and as I say, or reject. And in this case, ministers took a different, reached different reasons for their approval, neither in specifically endorsing or specifically disagreeing with.
And I accept that fully, except that the date of the decision predated the revised draft NPF4. So the minister's decision was, when it referred to emerging policy, it referred to the very first draft of NPF4, which, as we know, was substantially different.
It did predate it by about 6 or 7 days. I'm sure that Scottish Government think they have joined up thinking. I'll say no more than that. Thank you.
Right. I think that was something I wanted to discuss. We're just about at 1 o'clock, which is perfect time. Is there anything on onshore wind policy that you want to raise before we go for lunch? I think, Dr. Donoghue, remember your microphone.
Got a couple of quick points, ma'am. I just want to refer you to section 3.55 of the onshore wind farm document. The bottom half of that paragraph. The overarching aim is to enable the protection and restoration of local biodiversity, ensuring that wind energy can be deployed in harmony with, rather than at detriment to the essential protection and regeneration of our natural environment. I think that's directly relevant to this inquiry and the decisions that it makes. And I also note the essential protection element, which again follows through from the NPF4 comments about priority given to conservation rather than anything else. So yes, bottom section of 3.55. And then when you're ready, ma'am, just one more final point. Fine. Then just below that, 3.56, you'll see about 2/3 down. It says to contribute significantly to our biodiversity ambition, full stop, by proactively managing intact habitats and the species they support. Again, I think that's crucial, intact habitats. Again, I'd ask the inquiry to look at how the applicant's proposal can be reconciled with both those two sections. And our submissions speak to that. Now, just on that intact habitats, I'll refer you back to my inquiry reports and precognitions where I talked about the scientific basis of the importance of intact habitats and the avoidance of fragmentation. So just as a refresher for you, but in my inquiry report, it's from paragraph 20 onwards, where the relevant scientific literature is clearly laid out. And again, it's nice to see that policy is very well aligned with the scientific literature.
Mr. Woodfield, do you want to come back in on that as well?
It's a very, very quick point, ma'am, just to say that Annex 1, which was referred to by Ms. Sidgwick, it's very notable that it very focused on peatland restoration projects, which, as you'd have seen from our hearing statement, wind farms can make a significant contribution to peatland restoration. That doesn't really apply in this case. And what's notable by its absence from Annex 1 is any examples of best practice which relate to improving wildcat conservation. So we are in uncharted territory and certainly not within established best practice territory.
And does the applicant want to come back on those points?
I don't think so. I think we've covered it already in earlier discussions.
Fine. Well, I think that's us at the end of the onshore wind policy statement. And we're just spot on 1 o'clock. I'm happy to stop there for lunch and we'll come back to do the LDP after lunch. I would normally stop for an hour, but I'm happy to take advice if everybody wants a shorter lunch than that, just to keep going. Does anybody have a view?
Half an hour, ma'am.
Half an hour, yeah.
Yep, half an hour, and then we'll reconvene at 1:30 and start looking at the local development plan at that point. Okay, thank you very much.
Well.
I think I've got everybody back on screen. Seems to be everybody that was due to return. Some of the videos aren't on yet. Mr. Professor Newman's not turned his video on yet. There he is. That's fine. That's great. So I left us about to start Aberdeenshire Local Development Plan 2023. We've talked about how we've got the up-to-date version with a 2023 date on it. Before that, we were kind of looking at the most up-to-date October 22 version. I think the council's position was that none of the policies that we were looking at that were determinate in this case were affected by the change between the October 22 and the 2023 version. So looking at it in the round, before I look at any specific policies, I've got a question rather like the one I had before. The council has provided a list of 11 broadly relevant LDP policies, as opposed to determinate ones, at paragraph 502 of Mr. Hewitt's statement. Are the other parties agreeable that we've got that gives us the right cross-section of policies, albeit we're going to look in more detail at C2, E1 and E2 today? Will I come back to the applicant on that when we've had a chance to look at that document?
Thank you. Yes, yes, broadly agree that the sort of C2 is the key policy, the renewable energy policy. I'd also say E1 and E2 are sort of most relevant. Some of the others, without looking at them in detail, may have elements and things that are relevant, but will be largely covered in the context of the C2 set of policies on renewable energy. I think we did talk quite in my hearing statement to the original hearing session about P4 and how that affected noise, and we came to a position where there was an agreed noise condition on that.
Does anybody else have a view on that list? It's just to clarify that I've got the right working list of relevant policies, and then policies where there is some area of dispute or some direct relevance to the areas of dispute between the parties. I'm not seeing anybody else indicating otherwise. Oh, Professor Newman?
I just wanted to ask, I had not been able to find a version of conditions that that includes the resolution of whether there would be biennial monitoring of the noise problem, because I think that would have been in the list of mitigations, and I couldn't find it there. Perhaps I'm looking in the wrong place.
Well, I think that it's an issue of where we are in the process. So my recollection of the hearing on conditions and when we looked at the noise matter was that the council and the applicant had agreed alternative approaches to addressing cumulative noise, or they hadn't agreed. They had said these are two approaches. We can't quite agree, and they were leaving that to me to recommend to ministers as to how that might move forward. And the issue of noise monitoring was similarly left. The council is advocating it and the applicant is reluctant, and it was left for me to make my recommendations. So technically there is no document in the public domain that shows how that matter was resolved. I think
it wasn't really resolved. They focused down onto what were the issues which were left for you to make the judgment on. Yes.
And then for that,
wording confused.
Yeah. No, And so I think, yeah, so basically what I think the council's position, and maybe I'll come back to the council to confirm that the council were reasonably happy that they had no longer had a strong grounds of objection on noise matters, because they had been feeling their way through the use of conditions and other means to resolve it. And perhaps the council could come back and just confirm that, but that's my recollection of where we left it.
Yes.
Yeah, that's fine. So
because I found it strange that the council had been taking the position there has to be before we can approve it, there has to be a definite description of mitigation or something like that, and yet there isn't a definite description of mitigation. There are two alternatives which have not been resolved. Right? Yes. Sorry. Thank you.
yeah, no, that's fine. So I think it might be that for the purposes of the broader inquiry, the council's policy in the LDP key policy, I've forgotten the number. There's the key policy deals with the issue of noise or nuisance. That might still be in the mix, but it's not one that the council seems to be resting their objection on. So I think that might be the best way to put it. If I take from that from the list of relevant LDP policies, I should maybe add in the equivalent policy that dealt with nuisance. Would that be a fair position for today's hearing?
Yes, I mean, I also had some difficulty with which policies were actually could be found with the P numbering, but clearly C 2.4 is the as far as I can see the main policy relating to amenity in the local development plan. Am I not right there? Policy C 2.4, yes.
Yeah, we're probably going to come back to the details of these individual policies further on into to my points. I was just really looking at the broad list just now. So I was trying to find the right reference. Reading it just now. Maybe the council could have a look at that and
Ma'am, C 2.4 does cover noise issues, so it
yeah.
would be been under C in any of C2.
Yeah, it's covered in any event. Okay. Well, I'm going to come back to that in more detail, Professor Newman. So please, I'm going to look at the noise matters again briefly in our course of our discussions. So what I want to do now with my next point is really just this spatial framework. We talked about at the very start of today's discussions that the spatial framework requirement from SPP will effectively go in a few days' time. The council has just adopted a local development plan that still retains the spatial framework as part of its information, and C2 will make some references to it. So I'm just wondering how I should approach the LDP's use. I think they call it the climate change map, and the spatial framework that's within it. Does it have any specific status now that there's no requirement from SPP to provide one? Maybe start with the council and see if they've got a view on how I should approach the spatial framework as it stands.
Yes, thank you, ma'am. So I'm sure you can appreciate this is still something that we as an organisation are working out how our LDP sits with NPF4. But the latest advice that we've had from our policy team is that we're no longer relying upon the spatial framework map to the same extent as we were before.
Ma'am, we're having difficulty in hearing Mr. Hewitt.
Limited weight should be afforded to the spatial framework map at this point in time. if it is used, it's very indicative at this stage in terms of identifying your one formerly three areas in the reading headline.
And no change.
And that's not a particular change in approach in terms of how we were using the spatial framework in the previous plan, which was as a starting point for the assessment, the determining point.
Right. Does the applicant want to come back to that? Did you hear Mr. Hewitt better there, Mr. Trinick? Was that coming through?
Yeah, not. It's going in and out. I think it's the something to do with the microphone. I don't know. We heard the essence anyway.
Okay, thank you. So does the applicant have a particular view on how the spatial framework should fit within the application of the local development plan?
I agree with Aberdeenshire Council. It's a useful starting point, and it shows that the site is suitable in principle, but other things must be considered before any decision can be reached.
My wonder is it obviously the NPF4 doesn't require LDPs to provide a spatial framework of this nature. But I felt that if an LDP, an older LDP had one, that there was nothing in NPF4 that said you must disregard it. Would that be the right interpretation, that there's nothing to say that you can't have one? It's just, it doesn't have an origin. It will no longer have an origin in SPP. I saw Mr. Finlay raise his hand there.
That raises a difficult question. I'm not sure it's necessarily going to detain you in this case, because the spatial framework had the site in effectively in group 3, so it was acceptable in principle which would be the same result applying NPF4 to it. Simply because you have an extra provision in an LDP that's not in SPP doesn't make it incompatible to engage the priority mechanism in the statute. But compatibility is not a matter of consistency as such, but you have to look both at the wording and the policy intent. And it's quite clear that the removal, as we discussed earlier, of the spatial framework from SPP was a clear policy intent of NPF4, although the impact in this case we say is minimal, but in other cases it might be significant. And one can only have one type of spatial framework. So this is the type of case where, and I don't wish to, because Aberdeenshire Council are still working through it, it's the type of case where the ultimate decision might be that to have two different spatial frameworks would be incompatible. But so at the moment, all we'd say is, as Mr. Hewitt said, is put less weight on it, or no significant weight on it, it's a good example of a difficult question which you might be able to dodge in this case.
Thank you. Does the applicant want to come back on that at all?
No, thank you.
Good call. So to go into the more detail around policy C2 and the different layers within it. Obviously it has an overarching renewable energy element to it, and then a specific wind energy element to it at C2.2. And it uses the word appropriate in a number of contexts. And I just want to, obviously I've asked the question about the climate change map and its function as a spatial framework. But in C2.2, we use the word, or the policy uses the word appropriate locations, taking into account the spatial framework mapping at the end of the policy section. And we've also got in C2.1 the use of appropriate sites. And again, at C2.3, there's a use of the word appropriately cited. And I know how I might take site and location differently, but I really wanted to check with the participants today as to whether or not you see that there being a difference between an appropriate location with a nod to the spatial framework and an appropriate site in the context of applying these different strands of policy C2. Maybe start with the council if you've had a think about this word appropriate.
We haven't thought about it. The word appropriate, it's another way of getting at the same balancing exercise that policy 4A gets to. I don't think, at least Mr. Ewart tells me, there's nowhere in the plan is there a guidance as to approve what that means. There may be factors that are relevant to it. In the difference between site and location, because I would hesitate to put too much weight on the precise wording, given that the wording location is used in respect to the spatial framework, which is largely overtaken by events. And I would urge you to take a broad view to C2.2, really, which is quite capable of being read compatibly with policy 4A and indeed policy 11, and to apply a combination of them both. That what policy C2 and C1 are getting at is that in terms of appropriate location or appropriate site are broadly similar. They're looking at the landscape and visual impacts of the development.
The applicant, Mr. Trinick, wants to respond on that.
I hadn't actually, this point hadn't occurred to me until you mentioned it. I think the advice in C22 is now of little weight. Inappropriate locations means looking at the climate change map anywhere within the jurisdiction of Aberdeenshire Council, since there are no no-go areas for wind farms within that jurisdiction. So I'm not sure that really helps at all. A location has been decided by policy. But in C2.3, appropriately cited and designed, absolutely that's relevant. And we refer back to policy 11E2 of the NPF4. But C2.2, I don't think can't be given any weight in terms of location. Obviously, we'll come on to the SLCA later.
Yeah, no, that's fine. Take point. Does anybody have a view on that issue before I move on? Well, that's fine. So I'm going to pick up on Professor Newman's concerns. Now, in policy C2.4, there's particular wording halfway down: unacceptable significant adverse effects on the amenity of dwelling houses, comma, such as from noise, comma, or on tourism and recreation interests. Now, I'm reading your statement, Professor Newman, as if you think that the noise concerns in that statement would apply to people being affected by noise when they're enjoying tourism or recreational interests in the vicinity of the site. Have I correctly read your statement? Is that what you meant? You need to put your microphone on. Oh, yeah, that's it.
I have to say, it's in a way the way that this is constructed, it's an invitation to pick it apart. I think, given taking as a bit of sort of evidence on the side, as it were, from what was written in the council's jot about conditions, says for the amenity of the area. It doesn't say for the amenity of the dwellings in the area. I think that it's probable that this was intended to include not the noise thing was intended to include those enjoying the cycling and walking and so on and so forth. But of course, I could be quite wrong, and it's not clearly worded. That is actually certainly true. So I think it's up to you to really decide what a reasonable interpretation of it is. But in any event, I think that if it doesn't strongly reinforce, it fits in with what I was arguing previously in my written submission in the original hearing.
Okay, so there's a doubt. I think it's down to probably grammar to a certain extent as to how you use the word noise in relation to the overarching purpose, which is unacceptable significant adverse effects. I wonder if the council's had a look at that wording since they saw Professor Newman's hearing statement, see whether what your take on it would be as to whether those commas around the phrase such as from noise, how they apply to the issue of amenity for dwellings or these other interests.
Yes, I think that the other case I would point you to within the plan would be within policy 4, and particularly policy P4.5, as another statement, which is another opportunity to explore the issue of noise on any receptor, not limited to dwelling houses, which may actually cover Professor Newman's point in a different way. That basically just says that when an air quality assessment or a noise impact assessment indicates that a proposed development could have a significant detrimental impact on air quality or noise levels, appropriate mitigation measures must be provided. So there's a section in the plan that's external to the wind farm policy, and that could cover that point from other receptors. As you'll be aware, obviously a noise impact assessment in various different receptors beyond simply residential properties.
But you don't have a particular view on whether or not how I should read that sentence in policy C24.
My instinct on policy C2.4 is that it is focused on amenity at large. Noise is referenced as an example for dwelling houses. I'm not sure the circumstance about how that has come about as a specific example within that policy. It may be something that was requested by members within that policy. But the thrust of that policy is looking at unacceptable significant adverse effects on amenity at large. For any of those receptors, I don't think that it would necessarily be reasonable to restrict looking at noise under that policy to simply dwelling houses. But I think that there is a grammatical point as you've raised, but it is covered elsewhere in the plan.
Okay. Probably go to the applicant, see if they've had a read of it, see what they make of it.
Yes, ma'am, we looked at this. I think it does bear a fairly clear interpretation. Unacceptable significant adverse effects on the amenity of dwelling houses, such as from noise, or on tourism and recreation interests, including core paths and other established routes, etc. I think that the noise advice relates to dwelling houses, and the advice in P4.5 has a wider interpretation. It simply says significant detrimental impact on noise levels. That could be anywhere.
So my interpretation of that is is then that whatever guidance we have as stands, not wanting to open up the discussion as such regarding X2 and the other preferred and recommended guidance, and how we handle noise on dwelling houses is still key in this case. There's no indication that we now need to look at noise in a different way using a different measurement.
Agreed.
Yeah, that's agreed. Only coming to that sentence, interpreting it, if you were to adopt a legal interpretation, the effect of the comment such as from noise is one example. It doesn't exclude that example from applying elsewhere. It is just giving at one instance any unacceptable significant adverse effect, which can include noise. It could include anything else. So Mr. Hewitt, in respect, had it correct. Noise is not limited to being an impact on residential, on the amenity of dwelling houses. It could be an impact elsewhere, but it is singled out for dwelling houses because that's when it's going to be likely to be most relevant.
Okay. So it's the emphasis, by using the example to create an emphasis rather than to say it's solely that issue. Professor Newman, I'm conscious you got your hand up as obviously wanting to come back on that point.
Yes, I just wanted to say that as far as I can see, the substantive issue really seemed to be about whether the applicant would be required to conduct monitoring biennially throughout the lifetime of the project, or whether it would just be done as a one-off, and not a continuous monitoring as the council was wanting to require. And I think probably that still remains to be decided, and that may well be the main issue on which you have to decide, rather than just the interpretation of this bit in the local development plan, which, as I say, seems to be of the same mind, if you like, as the councils wish to have more rigorous and regular monitoring throughout the lifetime of the wind farm.
I'm not seeing anything in the wording of the policy that introduces the concept of monitoring, but I'll.
No, that was the original. That was the issue where I think this issue originally arose, if you see what I mean.
Oh yeah, I appreciate the issue of
as to whether the amenity to be protected was only the amenity of the dwelling houses, or was it the amenity of the whole recreational area, the whole forest in its capacity as a recreational area.
The only thing I would say is that my recollection, and please keep me right here because it is a while ago, is that the monitoring, if monitoring is introduced by condition, would be residential houses. It would be monitoring of the particular locations that were considered to be vulnerable because they were on the edge of the cumulative noise effects. I don't think there was ever any indication that noise monitoring was going to look at noise in the broadest sense. It was going to look at ETSU compliance at key locations. Does anybody have another interpretation? I see Mr. Trinick's nodding his head, so I think his recollection is the same as mine. Does the council have a view on that from their recollection of the discussions?
We agree with you and Mr. Trinick.
Right, so I think I don't. Do you have any comments? Any more comments on that particular element of policy C2 for Mr. Newman for a special Newman?
No, that's all I wanted to really raise. Thank you.
Fine, thank you. Does anybody want to raise anything else on the noise element of the policy? No, I think we're okay with that. That takes us on to, I think, policy E2. I'm going to deal with the landscape matters first. That's at page.
Sorry, ma'am, there is one more point on.
Oh, sorry.
C2. That is to note that tourism is still included within C2. I'm not saying that amounts to incompatibility as opposed to inconsistency. That's a matter of judgment. But policy 11 in NPF4 omits, in comparison with SPP, the factor of tourism.
I don't think that was disputed by the council at all. I think they'd potentially recognised the same issue. Is that correct?
It's not. Yes, it's been taken off. There's no necessary incompatibility, but obviously it would be a matter that would go to weight, and indeed elsewhere, Scottish Government's made its view on tourism impacts from renewable energy developments quite clear, and it's the absence of it in policy 11 is confirmation of that it's clearly relevant to weight, but we would submit not to incompatibility.
Agreed.
That's fine, thank you. Was there anything else in C2 that you want to raise? And sorry, I passed over that. Anything from the council's point of view?
Do you need to raise?
There's just one issue I'd like to raise, if I may, and it is that policy C2 doesn't have the balance in it that is sitting in policy 11 of NPF4 to take into account and attach significant weight to contributions to the renewables targets. And the other issue is the way in which the reference and any reliance to be placed on the strategic landscape capacity assessment, which is referred to in part C2.2, and where and what NPF4 tells us about the use of landscape capacity studies, or rather sensitivity studies, and the way in which they're to be used.
Yeah, I had noticed that. Sorry, I didn't ask a specific question on that because I found the council's evidence was broadly aligning with yours. Would that be correct, Mr. Finlay, in terms of the use of the capacity assessment?
Yeah,
I think that's right.
I understand it is. It's the AWPS that deals with sensitivity studies, which I think is what my recollection is what we'd agree to the capacity assessment is, in fact. So 3.6.5 to 6, there's guidance on use of sensitivity studies, but I don't think there's a significant disagreement between us as to how it should be used.
I don't think there is. I think I agree with that. Perhaps the difference is in the word capacity as opposed to sensitivity, that it would be inappropriate to try to determine capacity by reference to the SLCA. It is perfectly appropriate to use it to determine relative sensitivity.
Mr. Finlay, do you agree with that summary?
Yes, it's just the title of the document is a capacity study, but in fact, the reality is it's a sensitivity assessment.
Yeah. My recollection is that's where I think you'd got to during the inquiry session on landscape matters. Right. So that takes us very neatly into landscape matters under policy E2 and page 60 of the LDP, just a minute. Yeah, quite a short policy compared to the others, but so it's highlighting the issue of unacceptable effects on natural landscape elements. That includes landscape qualities and character drawn from landscape character assessments. That's this different document, which we did have in evidence, or we do have in evidence. I'm really looking at whether or not what the difference is between the test embedded in this and the test embedded in policy 11E or NPF policy 4A. Where is this taking us in a different direction? Is it as a strict? Is it a looser worded test? So I'm interested in your comparison between E21 and the policy 4 and policy 11 of NPF4. Probably start with the council, I think, maybe.
There is difference of phrasing, but in our submission, they can be read compatibly one with the other, and there is no significant difference in either intention, policy intent, or real application. We're not, I think, to use an expression that Mr. Chinnick's using, passing these documents as legal legal contracts. Our view is that they are broadly consistent, and there's no need to get too concerned about the wording. They're aimed at entirely the same intent.
Janice or Ms. Sidgwick, do you want to come back on that?
Yes, please. I think what we have to remember is that the policies, and this applies as much to E2 as it also applies to E1, which is next on your agenda, I think. They were all prepared in the context of SPP and NPF3, both of which date back to 2014. And that doesn't reflect the current context that we have in NPF4, or will have on the 13th of February once it is approved and adopted. And that's the need to balance the climate and nature crisis with others and give them significant weight in the decision-making balance for any application. All of the policies that are contained within the Aberdeenshire local development plan, need to be applied in a way in which, so that they are consistent with NPF4. And as I say, that means that the significant weight to be attached to the nature crisis and the climate crisis must come into play. But we don't have any difficulty per se with the wording of them. It's the way in which they're used and the context in which they are applied.
That's quite clear. Thank you. That was helpful. Your approach to that. I don't have any other queries on E2 landscape. Does anybody else want to draw anything out from E2 before I move on? And so that takes me down to policy E1, which is the natural heritage element. Get that up. There's obviously quite a few strands to this policy. And my question is around the tests for protected species. So that's at E1.6 on page 58, digital page 58 of the document. As to whether or not, again, in a way similar to the landscape question, whether or not these tests that are set here must seek to avoid any unacceptable detrimental impact, and then the rest of the text, development affecting protected species only permitted where it can be justified. Whether there's anything in that that is setting a different approach from NPF4 in terms of handling the protected species that might be present at Clashindarroch. Maybe start with the applicant in this case.
I think it would just reiterate the answer I gave in respect of the previous policy E2. It's the context in which the policies are considered. They were drafted in the context of previous policy. We now have new policy and they need to be considered in that context.
Could I add there, ma'am, that so far as European protected species are concerned, the tests set out in policy E16 are, I think, inappropriately harsh. So any effect results in the need to demonstrate imperative reasons of overriding public interest, no other satisfactory solution, and the maintenance of the population of favourable conservation status. I'd ask you to rely rather on what the habitats regulations actually require in terms of demonstrating the lack of an impact which could give rise to an offence. I don't want to start making submissions on that now, because you have my submissions on that point in my closing submissions already delivered. But I think that B16 goes unnecessarily far in its protection of EPS.
Mr. Woodfield, I think probably you wanted to come in on this point, and then I think Dr. O'Donoghue too.
Thank you, ma'am. Yes, slightly surprised by Mr. Trinick's answer, because what I see here is something that's in alignment with the habitats regulations and with the conservation regulations. And obviously, the tests that apply here effectively replicate the tests that would apply for licensing, but in a situation where this situation where the receptor species is so critically endangered, they would seem to be an appropriate and sensible and proportionate way of implementing the elevated status of the nature crisis in relation to protected species. So yeah, I don't know if Mr. Trinick is trying to drive a wedge between the implementation of the regulations.
That's quite different
through policy.
Yeah, just
Mr. Trinick, we can hear your conversation.
Yeah.
Oh, I'm so sorry, ma'am.
Yeah, no, just so you're aware. Sorry, Mr. Woodfield, would like to kind of repeat that last point, please? Sorry.
No, really, it was just I think I've already heard Mr. Trinick's answer. That effectively that he's suggesting that this is somehow different, but obviously planning authorities, as we know, have to satisfy themselves in relation to the tests. There are all manner of elements of case law, which I'm sure Mr. Trinick will know vastly better than myself, around the application of the tests through planning policy. But to the extent that this elements of the policy effectively just replicates those tests, I don't see a huge problem with it. I would have thought if there was a problem, if there was a legal fundamental problem with it, that would have been picked up through the process of adopting the local plan.
Ma'am, if I may come back on that, one would hope so, but doesn't always happen. But looking at the habitats regulations, in order to transgress those regulations, anything you do has got to be deliberate, which includes reckless, and it's got to be disturbance or damage or destruction of a breeding site or resting place of, in this case, the wild cat. I think that the policy E16 doesn't allow for what might be an effect falling short of an offence, and that is my point.
I think Paul O'Donoghue, you were wanting to come in on this point.
Yes, ma'am. Similar to what Peter was saying, I think the applicant's trying to make a divergence between the local planning policy and NPF4. But actually, if you look at the wording, imperative reasons of overriding public interest, that's very similar to the wording in the relevant sections in NPF4. There is no other satisfactory solution. That is very similar to points made in NPF4 about avoidance, the mitigation hierarchy. And the third point about population being maintained at favourable conservation status in its natural range. Again, those words, that phrasing is embedded in policy 3 of NPF4. So I think actually contrary to Mr. Trinick and Ms. Sedgwick's presentation of the plaques, the two documents are very closely aligned. In fact, they mirror each other almost perfectly. And one point to make is it's not each of those conditions, it's and, not or. So yeah, all three needs to be met. And as Mr. Trinick says, that's a significant bar to cross, which is rightly so when you're talking about protected species. And that's the reason why the bar is set so high, is so that this very kind of development that threatens endangered protected species is subject to such scrutiny. And it's also, just to reinforce the point in the legislation, obtaining licenses to disturb wildcats is extremely difficult. And there must be a whole range of criteria met for that. And again, the bar for getting such licenses is incredibly high. And that simply reflects, that is how the regulations are set up. And the LDP here and NPF4 mirror that perfectly. And appropriately.
Yeah, thank you. That's great. Does anybody want to come back on those points? I don't know, the council, you don't really have a particular view on the protected species policy, but if there's anything you want to add?
No, ma'am, I don't have much for us to add to that discussion.
That's fine.
Just one more point as well on that document. It's relevant. So it says, in all cases where there is uncertainty regarding the impact of development, but there are good scientific grounds that scientific irreversible damage could occur, the precautionary principle will apply. And again, that directly mirrors the wording in NPF4 Policy 3. It is a mirror of it. It is the same wording. There is not a divergent approach. It's entirely aligned. And the common theme through all three documents we've discussed so far, ma'am, is exactly the same. It's the avoidance, or it's the avoiding uncertainty. Where that uncertainty occurs, the precautionary principle applies. Can you see the section in the document, ma'am?
I'm sorry, I'm at paragraph 1.6 or E1.6 protected species. I'm just looking for the one.
It's above that, ma'am. I've got it in a. I'll try and pull it out now. It'll be above that. If you go to page 57, ma'am.
All right, it's under the nature conservation sites. It's the tests under conservation sites.
No, it's actually just above that. It says in all cases. So you've got section 10, natural heritage and landscape, and the bottom paragraph before policy 1, natural heritage. You'll see it there.
Right.
So it's
in the introduction to the policy.
Yeah, so it's front and centre, and yeah, it mirrors exactly NPF4. Where the precautionary principle is central, which again makes common sense, and again is reinforced by the scientific literature.
Okay.
So sorry, ma'am. And then just while we're on that section, if you just look 2 paragraphs above that point, you'll see that the council continues to be concerned about the loss of damage to landscapes, habitats, forestry, woodlands, and biodiversity. And you can read the rest. Again, that mirrors NPF4 and the priority to given to biodiversity crisis.
Right, that's fine. So that's me got to the end of questions. I think, yeah, that's the end of my questions on the LDP policies. Were there any other policies anybody wanted to raise in any depth? I mean, we covered the issue of whether we had a comprehensive list or not. Is there anything I've missed from these 3 key policies?
Just one final point, and it's in the LDP. So development will not be allowed if it fragments habitat or is not designed to minimise any adverse effects on the site's environmental quality, ecological status or viability. That's underneath the species section. It's an important point.
Which paragraph are you in now? Are you in E16 or are you in the bullet points on page 59?
Below that somewhere. I'm just trying to find it. I've got it in notes in Word documents, trying to find the paragraph in there. In the yes, so sorry, E1.9, ma'am, just under
1.9.
Yeah. Development will not be allowed if it fragments. That's all. It's not designed to minimise any adverse impact on the site's environmental quality, status or viability. You'll note that I talked about fragmentation and quoted comments about intact habitat in both the NPF4 section and the onshore wind policy document. The onshore wind 3.56 in the onshore wind policy document refers directly to the intact, keeping habitat intact.
So you're wanting to highlight E1.9 because of the habitat fragmentation issue. That's fine.
And that is mirrored in both the onshore wind policy document and NPF4.
Does the applicant want to come back on the relevance of those points? And
I think you have our case, ma'am.
Sure, you've got an opportunity there. Well, my question then was really just, was there anything else in the other policies, not the ones we've just been discussing, that I've missed that you want to highlight to me before I leave the LDP? Everybody seems okay, that's fine. And that just brings us to the last item, which is the draft energy strategy and the just transition plan from 2023. Just remind everybody, turn their microphones off. I'm guessing some microphones kind of interfering with the recording. I think, Professor Newman, you might have your microphone on.
I beg your pardon.
No, that's okay, thank you. So I've got your hearing statements on this, and in all cases you're highlighting that it's still a draft document. It's obviously been published for consultation purposes just at the beginning of January. I don't have any specific questions on it to take you to particular paragraphs or anything, but I just wanted to know what you would want to highlight to me as having a particular bearing in terms of things like the things we've talked about today, weight or balance, with specific regard to onshore wind issues. And I'd really just hand that over to you if there's anything you really want to draw my attention to. Otherwise, I'm quite happy to progress with the summaries and the hearing statements. I see Mr. Woodfield's got in first there, so we'll maybe ask him to raise his points.
Just a very short point, ma'am. Just again, throughout the document, there is reference to the mitigation hierarchy, to the need to avoid in the first instance, to protect, to conserve, but it comes first, rather than defaulting to later stages of the mitigation hierarchy, such as minimization of effects or seeking to compensate for them. So again, fully in alignment with the thrust of emerging policy in the other documents we've discussed today.
Does the council wish to highlight anything on this particular document that in terms of the way we should apply weight or balance?
We wouldn't have anything to add beyond the written statement.
And just returning to the applicant then, if there's anything they want to highlight from it.
No, there isn't, ma'am. We're happy to rely on the hearing statement. Just an open question to Mr. through you to Mr. Wood, Dr. Woodfield. I'm not quite sure. I'm happy to be told I'm wrong. What is the specific reference to mitigation hierarchy in this document? I'm sure you're right. There is a reference, but can you take me to it?
Let me take you. Okay, so for example, page 172, adaptation, biodiversity and environment. The energy transition supports Scotland's ambitions for restoring nature and biodiversity, including by carefully managing and avoiding potential negative impacts in Scotland and overseas. As part of our joined up approach to tackling the climate and nature crises, that's towards the end of that page, 172. There are other references which biodiversity. So this is on page 23. Our biodiversity, habitats and natural environment would have been protected and enhanced as part of the energy transition. So the emphasis on the word protection coming before enhancement there. It's consistent with the mitigation hierarchy. And
Mr. Woodfield, what was that page number again? I looked away or I was listening.
It was page 23, Ma'am, at the top, maximising. There's a green box, maximise it. And then the next one, perhaps just as a final example, on page 25, the fourth bullet down, it says, ensure the energy transition supports Scotland's ambitions for restoring nature and reversing biodiversity loss, including through avoidance of negative impacts and promotion of nature-based solutions. So again, entirely consistent with the mitigation hierarchy.
You get a silver star. Well done for reading it.
Thank you.
Okay. So I'm just going to leave the draft energy strategy now. So if anybody, unless anybody wants to draw anything else to my attention about that document, I'll move on. So I think that's us. So the next item is reporters' concluding remarks. So I'll maybe start with just a summary of what we agreed about some extra information today. Firstly, that we accept the Chief Planner's letter, the transitional position. We add it as a new core document with the next number in the sequence. Can't remember what that would be. That we accept into evidence the Brodie's blog extract. And we allow Mr. Trinick certainly a chance to submit a written response to that. We need to agree a time, and I'll need to decide, obviously, is it appropriate that others may have an opportunity to comment on that at the same time? Or is anybody minded to comment on Brodie's blog? Mr. Finlay?
Well, based on past experience, we may wish to have a brief chance to respond to Mr. Trinick's comments. I don't think that will take us more than a day or two, so I don't think we'll add to the timetable. But if it's going to, I don't wish to restrict what he puts in, but it may contain evidence, and we would like to be able to comment on that. But I don't think that's going to add significantly to any timetable, because I can anticipate what is likely to be said.
Okay.
No surprise. It'll be the same as for, forgive me for referring to another hearing, but the same as for the Kirkham document.
Right. Okay. So what would be the timescale? Mr. Woodfield, would you wanting to make comments on that document?
Not necessarily make comments, Ma'am, but just the opportunity to review it. And I suspect we're unlikely to want to make comments on it. But I would certainly be grateful for the opportunity to at least review it and check that it that we have no objections to it.
Okay. So I was obviously conscious I was trying not to avoid any kind of extended delay beyond the end of the hearing. Certainly wasn't going to invite closing submissions in writing. So I'm looking at quite a tight timescale for this then. Is it possible to have everybody's comments on Brodie's blog by Monday coming? And then perhaps to the council just to catch up on that with a couple of days later by the Wednesday. I mean, if you've got an idea what each other's going to say because of other cases, would that be all right with you, Mr. Whitfield? You managed to have a look at it and provide some comments. It is just 2 pages. I don't see it's a huge, yeah, it's huge ask. So that's Monday, and then the following Wednesday, or the immediate Wednesday thereafter. Just check those dates on it, Irie. It's Monday the 13th, followed by Wednesday the 15th. Just to tidy that up. And I think we agreed, and you correct me if I'm wrong, but I think we were all in agreement that the Rothis decisions, they were already accepted into the core document list, and that I am commended to read them and consider the differences in approach to Mr. Seaton's advice and then the Minister's decision. And I think I'm happy with that, unless you specifically want to raise written submissions on it. But I'm quite happy to do that and look at the difference, taking on board that. So those were the 3 action points I saw from today. I did, however, want to, before leaving the case fully, I wanted to know if, in the light of our discussions today, anybody wants to just sum up anything that they feel that they need to reiterate or reconfirm, just as a result of the way the discussions have gone or the information that's come forward, and just to give everybody an opportunity to do that. I've not forewarned you. It's just if there's a feeling or anything you really want to come back to that you feel merits a summing up at the end. I'll probably start with the council if there was something.
No, there is nothing. I think our position could be briefly stated. NPF4 and OWPS clearly bring some very significant changes into the planning system, but in terms of their actual application to this proposal in our submission, the position is set out in Mr. Hewitt's statement.
Mr. Woodfield, did you feel the need to sum anything up from what we've discussed?
Not really. Everything we've discussed and heard today, of course, with our hearing statement, which effectively is that to the extent that there has been shifts in the policy framework at national and local level, they underline the compunction towards choosing an alternative site.
And that, Mr. Newman, sorry, Professor Newman, is anything you want to raise? No, you're fine. So just to come back to Mr. Trinick, if there's anything you want to respond as a summing up?
Nothing, ma'am. We've had a very good opportunity to have our say. Not surprisingly, we take the view, based on what I've already said, that NPF4 does make a big difference and that it does shift the planning balance in the way that I've already submitted. Thank you.
Right, okay. Well, that brings us to the end of the hearing. Thank you very much for your contribution and for taking the time out to come along, well, to sit in your office and join this online meeting. In terms of the next steps, the ministers have asked that I provide an update to my previous report, which I know you haven't seen. So that is what I'll be focusing on in the coming weeks to try and make sure I can complete that as far as possible by the end of February. And really that brings the session to a close. I look forward to receiving the short exchange on the Brodie's blog, and I don't think that's going to cause me any difficulty in allowing me to progress with the work I have ahead of me. So thank you very much, and that's the hearing session finished.